Clock. Okay. This meeting is called to order. I am Mayor Beverly H. Burks, and this is the City Council work session agenda for Tuesday, July 29th. At this time, we will do roll call starting with Vice Mayor Johnson, Councilman Carroll, Councilwoman Hood, present. Councilwoman Bell, Councilman Perkins, and Councilwoman Adee. I'd like to also recognize our city manager, Ms. Shaquia Miller-Thornton. And at this time, are there any updates or changes to the agenda? Hearing none, we will proceed with the agenda with common consent. We'll move now into 3, which is public comments. Any member of the public may address questions or comments to the City Council referencing only agenda items after the mayor and council have had the opportunity to discuss the agenda item. Each attendee will be allowed 3 minutes for comments. There's no presentations or administrative business, and we will move into 5, which is old business. A, to discuss an ordinance to amend the Clarkston Zoning Ordinance to add definitions and use regulation for child daycare, adult daycare, convenience stores, grocery stores, fitness centers, and small food retail. And that will be done by our planning director, Mr. Edwards. And you have a full agenda, don't you? Okay.
All right, can you hear me now? There we go. All right, so you originally heard this one in May and it was deferred for 2 months, but at this time staff does not feel like we've gotten enough public feedback from business owners to move this forward, so we are requesting a deferral for 1 more month to make sure we can reach out to some more business owners to make sure this is what it needs to be.
Okay, thank you very much. And council, are you fine with that?
Yes.
Okay, perfect. All right.
And point of order, do we need to take a formal vote on that to defer it at the next meeting, or can we do that? So we just put it on the consent to defer for a month?
Yes, we can put as consent to defer, if that is fine for the council, correct? Okay, so that's what we'll do, consent to defer. Next, we'll move to discuss an ordinance to amend the Clarkston Zoning Ordinance to require a mix of land uses with projects in the Town Center TC zoning district for parcels over 1 acre in size, and that is Mr. Edwards as well.
Right, thank you, Mayor and Council. So on this one, the Town Center District's purpose and intent is to promote a mix of residential, business, commercial, office, institutional, culture, and entertainment activities for workers, visitors, and residents. And staff has frequently heard that we need a larger mix of uses within our downtown. And with this, we did some research, and this text amendment would require that any lot zone TC, which is Town Center, and over 1 acre in size, to provide a mix of land uses with major redevelopments and new developments. And at this time, over 1 acre in the Town Center zoning district, there are only 4 parcels that meet that criteria. And between last time we saw this and this reading, staff had also gotten questions about what it would look like if it was 0.75 to 0.99 acres as well, just to kind of get an idea of what the range is there. And if it's 0.7 and up, there are only 8 parcels within Town Center that would be affected by this. And since this was another deferred item, I went in and put some more research for you, which is the minimum acreage size for different cities and their mixed-use zoning. For example, Douglasville was how this ordinance was kind of drafted, and it shows their percentage of land use. Then we've got Forest Park, which actually has minimum density requirements, so buildings have to be between 2 and 3. There's 6 to 12 units acres for residential density, and commercial spaces have to be between 3,000 and 5,000. And there's some other examples in there that I will let y'all read. And with that, staff is recommending approval of this, and I will turn it back over to the mayor for any questions from the council.
Okay, thank you very much. And council, at this time, do you have any questions on this item? Okay. Public, do you have any questions on this particular item? Okay, hearing none. With this amendment, this will just go on consent for this one. Have another reading for it.
We don't have a multiple reading requirement other than in the ordinance that the council approved at the end of last year. I think we required that the item be on a work session agenda, which has just happened.
Right.
And I believe that this being old business, we had the public hearing for this previously. So this is eligible to proceed by consent if that's the council's desire.
Okay. Is that the council's desire for this one? Yes, Councilwoman Bell.
I think just a point of clarity. I know Richard gave us 2 options, 0.75 and 1 acre. Do we choose to go with as the writing or with the 1 acre? Over 1 acre, or do y'all?
I
So-
was going with the recommendation.
So council, if you want to go with the recommendation of 1 acre, then that's fine. Then we wouldn't have to do anything in terms of making this a consent agenda item. But if you wanted to do 0.75, then that would mean that we would have to go through the entire process.
So we got a consensus on what everybody want to do over 1 acre?
Yes, so does everyone want to do 1 acre? Yes.
I think we should say equal to or greater than, so that there's a distinction between it and less than an acre.
At least.
It just says a land greater than 1
1
acre,
acre.
is what it says right now.
Right.
So it's exactly 1 acre.
Then it would be over. Right. So do we have consent for 1 acre as is? Yes? Yes, okay.
Yeah, that's one thing.
Yes.
Mr. Edwards, when you looked at the number of parcels affected by this, were you looking at, to Councilwoman Hood's point, 1 acre or greater, or how was the math on that? I know we're kind of getting into the weeds here, but.
Yeah, so the way it works, the smallest parcel the closest parcel we have to 1 acre is 0.98, and then there's another one that's 1.02.
Okay.
So there's nothing that falls within that gray area there.
Okay. Just wanted to clarify. All right, thank you.
Okay, so still consent? Okay, thank you. So we're good with that one. Okay, thanks all. And then we'll move on to new business, and that will be 6A to discuss the Greenway Trail Phase 1 review committee's recommendation of the highest ranked consultant proposal for design, construction, plan, development, and right-of-way acquisition services, Mr. Kaiser. Don't do any doom and gloom with that, okay? All right, here we go.
Don't touch it, okay.
Okay, don't touch. Don't touch it.
Good evening, Madam Mayor, members of council. You have before you 32 pages of documents. I won't go through all of them, but I am going to hit some of the highlights here. So this is, you may recall the Greenway report had 10 different phases of project. Now that will be done over a period of who knows how many years, right? So what we did was we selected the segment of trail basically as low-hanging fruit. I wouldn't say low-hanging fruit. All these are going to be difficult to design and construct. But this was the easiest one. We wanted to have a showcase. We wanted a project that was a little bit easier than the other phases. So this segment from Montreal Road to Wild Circle is the segment that we are referring to here. So we put out to bid under our professional procurement policy, Brooks Act, requested qualifications from firms. We had about 6 firms actually submit qualifications. The reclamation committee then ranked the top 3, and then amongst the 3 that were top ranked, we had matrix, we had scoring spreadsheet, we had everything on both processes. And so of those 3 firms, we then asked for a technical proposal from all 3 firms. We ranked the 3 firms, again, based upon a matrix that we developed. Then once that occurred, the committee recommended the firm of Atkins Realis, formerly Atkins. They were bought out by a French firm many years ago. And then once that occurred, we went to step 3 under the Brooks Act, which is ask for a cost proposal, a fee proposal. So we did all that and negotiated a scope and fee. And I'm skipping over a lot of segments here because there's a lot to read here. I don't think the council needs to know every little detail. But essentially what we did was Again, accordance with the Brooks Act, which is the federal procurement policy, whenever there is federal funds on a phase of project or on a future phase, you have to follow the Brooks Act. It's a law. If you don't, then we can't apply for federal funds in the future. And so when the scope of work by Atkins and the fee was submitted, I negotiated both the scope and the fee. In looking at the project, I made the determination that instead of asking for a fee for all of the design services for phase one, which is there's 4 phases on a GDOT kind of project. There's concept phase, preliminary phase, construction phase, right-of-way acquisition phase, so forth. Decided to only go after the concept phase at this point. And the reason for that is we're not quite sure whether the trail needs to be on the north side or the south side of the creek. We're not sure exactly where it's going to go. We know the footprint, right? From Montreal to Wild Circle, but we don't know exactly where it's at. And so decided to go ahead and ask for a fee only for the concept work only. That concept work is $499,000 over a period of, work will be completed over a period of close to 11 months. There'll be in that concept work, all the details associated with concept work include surveying, includes public outreach, all the things that you do under a typical GDOT project under the concept phase. We're going to have some visualization, a program to where we have a 4-minute ride through the air on a drone showing what the trail is going to look like and all the amenities. So that will be part of how we present it to the public going forward. So it's going to be a nice presentation. And so that's where we are with the project. So from a future phases, we have Atkins. And when we get beyond the concept, we'll ask them for a cost to finish the project at that point in time. We won't know that until next April, at some point in time, next April, May period of time. So in the SPLOST program, I attached the 2023 SPLOST program the council approved of. I also submitted the 2024 bonded SPLOST program. So we have $700,000 under the Greenway project for design services. We are going to go over that amount next year. We're going to have to come back. I'll come back to the board, talk about where we can move some monies around on the bonded projects, on existing infrastructure projects that we have in the bonded program. Right now, I'm not worried about that. Right now, we want to get the concept done, and then we'll talk about that next year if council's okay with that. So again, I wanted the council to see, mayor to see where the projects laid out in both the 2023 program and the 2024 bonded program. And so, next steps. So we talked about negotiated fee, and what you have also in your package is a draft agreement for that concept phase only. Mr. Quinn has not seen it yet. What we typically do, him and I, is let the consulting firm look at the agreement for design services. We've done that before. Mr. Quinn has approved of the previous formats, the format in the years gone by. I use the same format I've always used, but I suspect the consulting firm will still have some tweaks that they would like us to consider. Once I get those back, sometime, most probably tomorrow or the next day, I'll forward on to Mr. Quinn, and we'll have something ready to go for council meeting next week if council decides to move forward with the concept work. I also included in your package a scope of work in the map of the project limits. Let me talk a little bit about the project limits. The trail is going to be anywhere from 10 to 12 feet wide, in that range. We're going to have a hawk signal crossing Montreal Road at the trailhead at Montreal, crossing on the other side of Montreal Road. And we have 2 sidewalks out there, east and west side of Montreal Road. So the trailhead is going to be right at the bridge where the creek is, Montreal Road. That's where one trailhead. There'll be a hawk signal, just like we have on North Indian Creek. On the east side, Wild Circle, that is where we're going to have to, during the construction in the future on this project, there'll be a pretty good ramp of fill, a lot of backfill, because if you know Wild Circle, you got a culvert there. We're going to have to bring a trail up to match the top of the roadway. because it doesn't meet ADA requirements now. And we don't want to put a trail under the bridge. We have to redo the entire bridge over the creek to put a trail under. It's just too narrow through there. And so there'll be some challenges, but all projects are like this, particularly when you're trying to run the trail next to a creek. And so in the floodplain. The other component that I asked for in the request for proposals a month ago was I wanted spur connections to the apartment complexes. I felt that was very important to be able to have somebody in an apartment complex to walk out their parking lot onto a connecting trail to the main trail along the creek. So we have 3 of those proposed in this concept work. No connections to residential homes, nothing of that nature, all up to apartment complexes. And again, that's one of the reasons also why we chose this phase of the work, because of the remaining 5 or 6 phases, 4 out of the 6 are behind people's homes or in front of people's homes. And again, we can deal with that in the future, but we wanted to see what we could do under phase 1, and that's what we have here. We're going to have 3 public meetings. There's going to be a lot of very intense work, just like the Safe Streets for All program, a lot of public outreach, a lot of translation, interpretation kind of work. So it's going to be a really, I think, a good project when we get this thing off the ground. So the project limit, scope of work, cost proposal is included in here, and the cost is also in the draft agreement. And we also have a schedule. So concept work would be completed right about April of next year. Put us in a very good time frame, because it's going to allow us at that point to pursue federal monies through Land and Regional Commission. Hopefully by that time we'll know something from the senator's office. So we'll have that pot of money. We'll have hopefully some ARC funding. It'll get us in the door for application. It'll take us another 15 months to finish design after April. We talked about that after April, because we got a lot of wetlands permitting. We've got Army Corps of Engineers. We have Fish and Wildlife. We have every agency under the sun that we have to deal with, because we're running this trail adjacent to the creek. We have 3 bridges proposed. It's a pretty hefty project, but compared to other segments, it's not so bad. Given the city has half of the parcels of land along the trail, which makes it a lot easier. There's like 11 parcels, I believe. The city has ownership of 5 or 6 of them, which makes it a little bit easier. We're also expecting during the right-of-way phase, and that's not part of this, we're not going to be negotiating right-of-way until later on. Once the design on the next phase of this begins next year, we're going to have right-of-way acquisition services as part of that. I'll talk a little bit about that. I fully expect, whether this happens or not, I fully expect donations from every apartment complex that owns property that touches the spur routes or the trail. And there are 4, I believe. And we haven't reached out to the property managers yet, the ownership yet. We're going to hope to do that during the concept work over the next 11 months. But that's what we're expecting, because it's a true benefit to those property owners and to those residents in those apartment complexes to be able to come out their door, walk down the spur route to the trail, to go to Wild Circle, go Friendship Forest, or to Montreal Road. And that's the whole purpose of the trail, right? Get off the road and get onto a nature trail. And that's what this provides. So that's all I have.
All right, thank you very much, Mr. Kaiser. At this time, do we have any questions from the council on this information? Okay, hearing none, I'll open this one to the public. Do we have anyone from the public who would like to speak on this one? Okay, yes, Councilwoman Bell.
Thank you. So my question is, I understand that anticipation.
I don't think is your mic on? No, press the button on the bottom.
I think it's on.
Press it forward, opposite way.
Okay, what about now? What about now?
You have to make it the eye down, to press the eye down.
It is.
It is.
Okay, well, speaking.
Oh, it's on now. Okay. So my question is around the spur donation, right? I know we anticipated, but is that going to be also in the budget or the scope like you have presented already, where there's an additional supersede what we already have?
Next year.
Okay, in the event that we don't get it
Then we have
now?
to buy it.
Okay. And then are there any concerns in regards to the federal funding and it not being there in accordance with the, with GDOT?
Who the heck knows?
Well, that's my concern.
I don't know. So we have a match that we allocated in the SPLOST, a local match. And so we won't know what the estimated cost of the project is until sometime next year. We're going to have a good number during the concept phase, but then we won't have a more defined number until after April, during the final design phase. And so I estimated the cost of construction right around $5 million. And I put in an application for $4 million, I think, or 3.5, $4 million. We have a match in the SPOS program of 1.5 million. So we don't know whether direct appropriations will be there as we apply for the application back in March. We don't even know if any federal monies are going to come to the Atlanta Regional Commission for any kind of project. We won't know that, but you know what? We have to still. So let's say there are no funds. That's not going to be the case. But let's just assume there's no funds. We take the project and put it on the shelf, buy the right of way, and be done with it. And wait till federal funds come in for construction. We don't have the money to build it ourselves. It's just too large of a price tag.
Well, that's why I asked the question in regards to our scenario, A and B. If we don't get the funds, what is the output that we're communicating? And if we do get the funds, how do we proceed on with an appropriate timeline so that we're not moving so slowly that whatever money that is coming down the pipeline is gone by time? It's time for us to move on.
No. So we'll be in really good shape after the concept work is done to apply for grants.
Okay.
All day long. And then we'll be in position, well, if the Atlanta Regional Commission asks for a call for projects, that always changes, particularly now, how much funding is going to come to the Atlanta area.
Right.
So typically it's the fall of every year. So when we finish this, so we'll be in a position to apply for federal funds in the fall of 26 for availability in 27. And that's how also we have lined up the senator's application as well, the CDS funding, the same time period, 27.
Okay.
Yeah, thank you. And so that federal funding from the appropriations, we'll know something by October
Yes.
timeframe.
Yeah, I think so.
So that can kind of help us out, and that's about $2 million with that.
Yeah, actually, 2.5 or something.
2.5, yep.
It's not enough, but it's going to be enough to go after some other federal funding.
Right. And Councilwoman Hood.
Thank you. Just to clarify, the 500,000 is the total cost for the concept phase
Yes,
only?
correct, only.
And how does that compare with the budget estimate of what this would
So
be?
we had 700,000 for all design phases. Concept, preliminary plans, final plans, and right-of-way plans. So as I said, I'll have to come back to you next year and look at the budget and see where we can. There are some areas that I think you'll be okay with next year when I present it to you, but I'm not going to go through that now. There's no
Okay.
reason to even discuss it.
Okay. So right now, we don't have a contract to approve.
No, but you will by next Tuesday.
Okay. All right. So this will have to go on the regular agenda.
correct.
And Councilwoman Bell? Okay. Thank you. So this will have to go on the regular agenda pending the review. So I'm going to ask you this, Mr. Kaiser.
Yes, ma'am.
So make sure we kind of step it back so that when we have the meetings, we can make sure we have that wonderful contract so we can look at it, make our city attorney's life easy. Would you do that?
Yes, ma'am.
Okay, I appreciate that. And also making sure that between the Greenway and the other concept projects that we have a complete list that you provide the city manager with so that we can make sure from a council to be able to participate as well as ensure that the community can give that input.
Yeah. So I apologize. This Greenway project came up, so when the bid opening happened and we went through negotiations, brought us up the very last minute, and I don't think I've done that in all my years of working with the city. So this is the first time. So that's not going to happen again.
Okay, thank you.
So I do have a question now.
Sure.
Is that enough time, Attorney Quinn, for you to review it and there are no delays for us to make a decision?
I believe that it will be. Mr. Kaiser mentioned earlier that he has a particular format for these contracts that we have worked with, the both of us, many times over the years. So my main answer is yes, it'll be fine. The only caveat to that is we don't know what this vendor might come to us with. So it's possible if they start proposing tons of changes, then we might have a timing issue, but hopefully that won't be the case.
And we gave you 2 extra days. How about that?
That's right.
That's right. Okay. There you go. Thank you very much to everyone. We'll move to the next item, which is B, and that is, you're not moving too far, are you? To discuss a resolution establishing a Vision Zero policy to work towards 0 traffic deaths and 0 severe injuries. Mr. Kaiser again.
Your first official action under the SS4A program. So one of the requirements from the Federal Highway Administration was for the elected officials to adopt a resolution with a goal of significant reductions in accidents, crashes, as well as deaths when you receive the SS4A grant. So what that entails, and you can see I'm not going to read all of it, but there's a lot of detail here about what has to be done during the SS4A program. So how this is accomplished is through public outreach, soliciting information from the public, from the users of the transportation system as to where they believe problems exist, how they believe problems can be corrected. It also includes us developing a whole bunch of countermeasures, all right, whatever those may be, traffic islands, roundabouts, road diets, striping, signage, a whole bunch of different vendors have different programs out there to help reduce accidents or eliminate accidents. Then there are policy recommendations. There are going to be, just to give you some heads up, there will be a bunch of policy changes and ordinance changes with this. It's going to be primarily around infrastructure, but we'll bring every one of those to you for consideration as they are developed by myself and the city manager and the consulting team and Mr. Edwards. And so there's a lot of work to do in the 13 months. So the project must be completed by September of 26. We can make it happen. We have Kimberly Horn's going to do a great job. They have laid out the scope. We have all agreed to the scope. We know what our responsibilities are. So we're going to make it happen. But this resolution is the first step. So here's what I put in the resolution in terms of the goals of City Council, what they need to adopt. A 50% reduction in accidents throughout the city by 2035. A majority of our accidents occur on the North Indian Creek corridor, North Indian Creek Drive corridor, which is also Montreal Road, from City of Tucker to city limits. All right? And so that's doable, and here's why. There is a reason for this. And so the reason that I put in 50% is 2035 is 10 years away. We have a road diet project in our SPOS program. This study will result in the city teaming with DeKalb County to improve the corridor, and that those corridor improvements were based upon what we develop in this SS4A program. We will then apply for federal funds to convert North Indian Creek Drive and Montreal Road into a road diet or some other similar kind of project. We believe when that happens, the accidents on North Indian Creek Drive and Montreal will be dramatically decreased. Now, can I look into a crystal ball and say it's going to be 50%? No. Does the Federal Highway Administration hold you up to that number? No. But what they do want to see is movement in the direction of policy changes, countermeasures being implemented, road projects, et cetera, being done over the next 10 years to where they see that there's an effort on the city side to make that happen. There are annual reports required from now until 2035. They have to be developed every year to show a positive direction in terms of reducing accidents. The second item that council will approve of in this resolution, you'll see it, is no deaths by 2040. no deaths from pedestrian accidents, from traffic accidents, from cyclist accidents, track crashes, no deaths. That's a goal. It's a goal, right? So the goal is we want to move in that direction. So it's very aggressive. It is not it's as aggressive as everybody else that has done these throughout the United States. Some a little bit less, and some a little bit more. I believe that's realistic. So again, Federal Highway is not going to come back to the next mayor 10 years from now, right, and say, why haven't you received this goal? Well, they may if they audit the program. The city has not done what they need to do on a yearly basis. So the yearly basis is collecting data, putting that data into the formulas that will be given to show what has been done in the city over that period of time. As long as they see there's progress being made, that's all they care about. Well, they care about no accidents and no deaths, right? But they want to see progress being made by the local government. And we will surely make that happen with this SS4A program. There's no doubt. And at the end of the day, we think that the Greenway project had a lot of public input, a lot of collaboration. This project does that 10 times better. There is a unbelievable amount of outreach. 30 to 35% of the fees associated with this project, the $1.25 million project, will go towards soliciting input, outreach, begging people to come in to speak to us, finding incentives for people to come in to speak to us. It's going to be very hefty, but we'll be able to make that happen with everybody's input and help with this. So that's the resolution. We need to have it approved and adopted, and that's where we are.
Okay. All right. Thank you very much for that overview, Mr. Kaiser. Don't go too far away. Okay. A couple of things, and I'll open it up to council. But first, do you have that kind of documentation to justify the 50%, just for us to make sure we have, you just picked it, but, for documentation for when someone else is here and we're not all on the council or whatever?
So about 75% from the records that I have from a couple years ago, you may not remember this, but the Georgia Department of Transportation did a safety audit on North Indian Creek Drive from Memorial Drive to Church Street about 6 years ago, funded by the state of Georgia. And 75% of the crashes that occurred were basically rear-end collisions. And so those rear-end collisions can be eliminated or reduced dramatically through slowing cars up, through a lot of different mechanisms, all right? And so I believe that when the countermeasures are installed, whether it's a road diet with 10-foot trails on both sides of the road and bike lanes and narrowing the streets up, all of that, plus various pedestrian crossings from Memorial Drive all the way through, I believe that 50% number is going to be work. It's going to work. It's going to happen. But we got to get those countermeasures in place.
Okay. And then do you have a schedule of all the policies that we have to make sure that we have in place for the city manager, so that from an agenda perspective, at least, we can kind of understand where we need to go?
Not yet.
Okay. So.
But she will.
Okay. And since we are talking about a master plan, this project, and the Greenway, we need to make sure that we have a comprehensive listing of how we're trying to do this engagement so that we can leverage these multiple activities potentially at the same time. So the staff and the city manager also needs that, as well as the council, to make sure that we're putting this as much as possible together at one time.
City manager's already mentioned that to me.
Okay.
And we've already talked to both consultants, both Kimberly Horn and Atkins, to try to be as efficient as possible with the public outreach. The public outreach on the Greenway project is a lot less intensive than this, but there are crossovers, and both consultants know that this is happening, and so they're going to be communicating with each other as well, so we'll make that happen.
Okay.
But we will make sure that the city manager has enough notice about policy changes before they happen. But I will tell you that the 13 months that we have, or 14 months, there's a lot to do. Staff will be able to handle it. But there's going to be a lot of stuff on your agenda almost every month
Okay.
going forward.
Okay. I just want to make sure as we're doing all of this that we're mindful and giving appropriate timelines for the staff to be
Yes.
able to act on it. And
Correct.
so I don't want it to be caught off guard. So
Correct.
thank you for that.
The second part of this, and I didn't even mention this, it's worthy to mention this, I think. DeKalb County government. So when we applied for the application 3 years ago for this project, I put in the application that the project go to Memorial Drive. And we solicited DeKalb County's input on that from an elected official standpoint. All I ask is that I'll do what I can on the staff level with the people I know to bring staff in. We may need some more than that.
I'll bring the CEO in.
Okay,
So
thank
I'll do that as
Okay.
well as having Zach and whomever else. So
Thank you.
we'll work with the city manager to make sure that we get that done. Councilwoman Bell.
Thank you, Mayor. So I got two questions, and this is yes or no. City Manager, you seen this resolution and you were fine with the language.
I think it's important that we be as aggressive as possible in the language. This sets us up really for application for future funding to complete the phases of this project. And so, yes, ma'am, I do think it's beneficial to be aggressive.
And aggressiveness is not my concern or question. My concern is around the oversight, accountability, and expectations listed in here, where the city manager basically is to form a working group. The city manager is also to ensure that the Vision Zero action plan addresses the priority policies as well as provides the annual report. Now, I understand that that's something that you can do. However, you also have staff that should be, I think, assisting at some point a part of this process because it directly relates to their work and the SOP. And so I see in the top part of this resolution, there is language that says basically that there's a staffer or departmental leadership that leads it with your oversight. And that's my question in regards to language.
Yes, ma'am. So I think it not uncommon that the city manager be charged with the responsibilities, understanding that there is an ability to delegate, right? We do that through our planning department, through our contract relationships with the engineering services. So I think that we have the capacity staff-wise at present, and I think even in the future, to make sure that we meet these requirements for reporting and things like that. We have to work administratively. We do have some work to do administratively to, put our contracts and our responsibilities, our annual reporting on a calendar or a cycle, or delegating within staff and making those expectations known so that we meet all of the requirements, not just of this particular project, but all of our reporting requirements. So, there is work to do, but I think it definitely can be accomplished.
So I definitely think it can be accomplished. My biggest concern is accountability, because this directly belongs to you. If stuff is not done, or whoever the city manager is at that time, right? And so I noticed that the language above says direct city administration and departmental leadership. And so if you're comfortable with the language as is, that's fine, but that makes it seem that you can delegate and that it does not fall on you and that you have that oversight ability for the execution of those deliverables listed in the resolution.
Right.
Do you know what I mean?
I do.
Okay.
I do, definitely. I think this is no different than the oversight that is given to the city manager for any operational aspect, right? So I have the responsibility, ultimate responsibility for the administration of operations, right? And then there's an opportunity within each job function each job function holds a different responsibility, but ultimately, I have the, I'm responsible for the oversight. So I don't look at this as any different than that. Yes,
Okay.
ma'am.
All right. Any questions from the council? Okay. Do we have anyone from the public who wants to speak on this particular item? Okay. Hearing none, is this okay for consent? Consent?
Yeah, let's do that.
Okay, all right, great. All right, then that leaves us to item 6C, which is to discuss an ordinance to amend a CUP 19-02 zoning conditions for 1352 Brockett Road. Mr. Edwards.
Thank you, Mayor and Council. So on this one, it is a resolution to amend the conditional use permit for the zoning conditions of CUP 1902 for 1352 Brockett Road to allow for a full-service auto repair shop, increase the number of vehicles for sale from 5 to 10, and to increase total vehicles on site from 15 to 25. So on this case here, it was June 2nd of 2020 that you all approved the conditional use permit to allow for the sale of vehicles on the site, used cars, with the existing use of emissions, oil changes, and tire repair use with the 9 conditions that were listed in the staff report. And now the applicant is requesting to modify conditions 1 and 2 to allow for the full-service auto repair shop, which would include transmission, engine, and other customarily completed auto body shop work. And further, condition 9 only allowed 5 vehicles for the sale on the property. The applicant is also requesting to increase that to 10 cars for sale on the property. And based on the existing use as an automobile broker, emissions, tire repair, and oil changes, the minimum parking requirements would be 20 spaces for this use. And it appears that the applicant only has 19 existing parking spaces on his property. And so with that, going into some of the conditions within our comprehensive plan, the NC2 zoning district purpose and intent is to provide suitable areas for the provision of retail and personal services oriented towards those neighborhoods making up the adjacent communities. And based on our current zoning ordinance, full-service auto repair shops are considered a light industrial use. These use types would be required to have zoning buffers when they abut commercial and residential uses. And this property currently has no buffer between the existing subway and only has a single row of trees and a metal picketed fence abutting the residential uses to the rear. And the comprehensive plan has the future land use classification for this property as traditional neighborhood development. This designation calls for walkable areas of single-family homes, duplexes and triplexes, cottage courtyard housing, and 4 to 6 unit walk-up apartment buildings with townhomes. And staff's interpretation is the increase in intensity for parking and more intense auto repair use would not be in line with the comprehensive plan nor the future development of surrounding properties. As recommends commercial uses that are low intensity and to scale to ensure compatibility with surrounding properties. So staff does believe that could impede the use of the property of adjacent uses. And with this, staff is recommending denial of the request to allow for a full-service auto repair shop, denial of the request to increase the number of cars for sale, and approval of an increase to 19 cars to be allowed on the property with the following conditions. And Madam Mayor, would you like me to read all of those out for you?
Sure.
Okay. This would be, and it's the 9 same conditions with a few of it modified. So it'd be condition 1, the business shall be limited to used car sales, oil changes, emissions, and tire repair. 2, the business shall not include or operate as a service station, park and ride lot, office for self-employed individuals, truck stop, paint and body shop, a transmission shop, a shop performing upholstery or glasswork, rebuild or restore vehicles, body work, painting, warranty work, storage for recreational vehicles, as a garage or other customary motor vehicle repair work. 3, there shall be no long-term parking or overnight parking along the front of the business. 4, the maximum number of cars for sale on the property at any time shall not exceed 5. 5, the owner shall adhere to section 12-20 disorderly conduct and 12-28 noise. 6, the business shall not emit noise, vibration, smoke, gas, fumes, or odors that would be a nuisance to the adjacent properties. The business shall comply with the Department of Natural Resources Environmental Protection Division policies and procedures and laws relating to air, land quality, environmental pollutants disposal, including tires and oil disposal. 8, the owner shall adhere to state and local requirements and licensing for used automobile sales. 9, contingent upon the continued existence of a signed parking agreement between the owner of Brava Auto Brokers and Subway at 1362 Brockett Road. The signed parking agreement shall be for a minimum of 1 parking space and a maximum of 5 parking spaces. 10, the parking agreement shall be renewed annually and submitted to the city of Clarkston with the annual business license renewal. 11, the applicant shall submit a parking lot plan to the Planning and Economic Development Director showing the location of the parking spaces designated for vehicles being sold, staff parking, and parking for vehicles waiting for service. And 12, the 5 parking spaces allotted for vehicles for sale shall be clearly designated by marking the parking surface with paint or by signage. And with that, I will turn it back over to the mayor for any questions.
Okay, at this time, council, first I want to make sure the applicant has a chance to speak. So I allow the applicant to speak. Okay.
Good evening. My name is Mohammed. I'm going to be representing my father, Abdul Qadir Dine, the owner of Brava Auto Brokers. We're here today asking for 2 reasonable things: permission for our business to operate as a full-service mechanic shop and a fair and realistic increase in the number of parking spaces we are allowed to use for auto sales and vehicle repairs. Right now, the city is limiting us to only oil changes, emission testing, and tire repairs, and only allowing a very small number of cars on the lot at any given time. This isn't really reasonable for a shop that is fully capable and fully equipped to handle much more. We have the tools, the equipment, and the space to safely perform full service work and manage more vehicles on site without causing traffic safety or environmental problems. We have invested a great deal over the years to make sure our facility meets the standards for this level of work. These investments into equipment, lifts, safety tools, and staff training were made specifically so that we can handle full service repairs safely and properly. Restricting us on both services and parking harms our business and makes it nearly impossible to operate competitively. While this is not a deciding factor, I think it's important to mention that when the property was under Tucker, it operated as only a full service mechanic shop, and that was allowed. When Clarkston annexed the property, we applied for authorization to add car sales, which was approved. I also want to mention some of the concerns that were mentioned against the shop. The first thing was the residential area adjacent to our property. I want to mention that we are already operating as a mechanic shop. Allowing full service repairs does not change the nature of the business. It simply allows us to perform work we are fully equipped for. We already know all safety and environmental regulations. Adding full service does not create any new risks. We have a fully fenced and gated property which acts as a buffer. Nothing we do spills over into the apartments. We do not perform any paint or body works, which are kinds of work that could create fumes. And we have never had a noise complaint in over almost a decade of operation. Now, I also want to mention the concern about the environmental issues. I think it's important to mention that we handle all of our fluids and parts through certified waste disposal companies, and there's no risk of ground contamination. Now, the other point that we come to is the concern of overcrowding of vehicles or parking spaces. I think it's kind of unreasonable to say that to only allow 5 for sales and 5 for repairs while there are approximately 25 parkings, as you have the pictures. If he can give y'all the pictures.
This one is a 6. This is a 6 right here. And this one is another 5. That's the yellow ones are for for sale cars. That's what this one is. This is the back of the cars. Probably like 25 cars.
And this is our property alone. And we also discussed about the annual agreement with the subway across from us. And I would say that this really shouldn't be necessary because our property alone has the capacity to be of use to our dealership. We have the capacity to handle our own. And the subway agreement was only brought if there was a case that we had to use the parking, which they agreed to. And an annual agreement renewal is kind of unreasonable. And they also mentioned that there should be a buffer between us and the subway. And subway is our neighbors. We like to treat our neighbors good. And they will not be benefited by that buffer. As if you look at the road, there's a straight path to that. And if we block them, they'll lose customers, or it will be very difficult for customers to go from our shop to them. And I want to bring the closing statement. We ask the city to work with us in good faith and allow our business to operate at the level it was built and equipped for. Denying us full service authorization and reasonable parking allocations will only harm a business that has operated responsibly for over a decade. Serving Clarkston residents and maintaining a clean, safe property, we're simply asking for the opportunity to continue doing that. Thank you.
Thank you. Okay, with that, I'll open it up to council for any comments at this time.
I have some questions for Mr. Edwards.
Yes, Mr. So you may sit down. Thank you so much.
So I have two questions. I'll start with the first one. So can you talk me through why you think a full service repair would be more detrimental to the neighbors than, the kind of repairs they're doing right now?
Yeah, so once you get into heavier, different types of equipment, for example, changing engines and stuff like that, it does become a bigger burden on the neighboring properties when it's a restaurant there with no buffer whatsoever. You could literally be standing at the front door of the subway and see them changing an engine. I think it's the perception of safety a lot there, and it is a slightly more intense use that the comprehensive plan and the zoning code do not call for.
And have we gotten Subway's input or thoughts on this, or do we know what?
From the last I heard, Subway has not renegotiated an agreement with this property owner, and we have not heard back from them based on conversations with Mr. Dine, but we've not directly reached out to the owner of Subway. No, sir.
Okay. And the second question I had is, so they say they have 25 spots already there, so they don't need the agreement with Subway. So can you talk me through kind of the rationale for requiring the Subway agreement as part of whether you increase it to 19 or 25 or whatever number you agree to? Why do they need the Subway agreement?
So the 25 was something that was brought to me before the meeting, so I have not had time to truly vet it and provide a professional response on that. But if they could provide 20 parking spots on the property, I don't see a need for the agreement with Subway. If they can fully prove that and the parking spaces do meet the dimensional requirements of our zoning code.
Okay, thanks. That's all I had.
All right, and Vice Mayor?
Okay, and my question is similar to Mr. Carroll's. You stated that the work being done is pretty much an eyesore for the residents around it. But looking at these photos, it's all indoors. And Subway is they're actually in the back of Subway. So if you're frequenting Subway, you really don't see the shop. So I get the comprehensive plan. And I did take the liberty of researching. That was a full body shop before he purchased and before we annexed. It took a little work, but it really was. So I get our ordinances. I get the work. He's there. He's been doing it. And if he can prove that these parking spaces, if you can verify these parking spaces, I think that would be great because I did go by there and he even has rear parking. So, yeah, that was and then my other question was, he's wanting 25 and we're giving him 19. Was that because of the additional parking that was being used by Subway?
Yes, ma'am.
Okay.
So based on the site plan that we received way back when the first one came through, there was only 19 spots on that site plan. And because there's not any way for you to park vertically between the subway and this building. So I don't think you get that many additional parking spaces in. He may be able to get 2 or 3 on that side. So based on my knowledge of the site, I think he could get 22 to 23 legal parking spaces on the site, but not based on the current design.
Okay, any other questions? Okay.
Well, I remember approving the cup in 2020 when you came to us. And I guess my question is, I got some questions around that subway because that was a huge hindrance, and you know that from the last time we discussed this in regards to the parking space and those things. And I get everything is indoor, but also I can't recall, but did we get an environmental study of some sort from you in regards to waste? Yes, that's somewhere documented. So I mean, that can also talk about the environmental impact of it, and also led us to making the decision that we made in 2020. So I think for me, I just need to figure out the situation with Subway because that was a huge hindrance in 2020. And so if you have any more insight on that, that would be helpful.
So before we submit the application, the parking wasn't marked, so that's what they come up on 19. But right now, we call the professional, then he painted. So we have right now, technically, even if you right now, if you can go right now, you can count it. We have 23 parking lot. We're not counting the back to the subway. If we add the back to the subway, then it's gonna add like almost 28. So even I'm not counting for the close to the back to the subway, the tire place. Only I'm counting this front side 13 parking, and I got here 7, and the tire place, then I got 5. So come like almost 23. So if we count it to add the other ones, it's gonna be like 27 or 25, 27.
Okay.
So even I'm not counting for the subway, even I don't need the subway to get the permit for the agreement. So because I have enough parking lot. So we just hired a professional that just market all of them.
Okay. And then we're gonna stop the back and forth, but I just want to make sure you have a chance. Go ahead, since you're there, I'm gonna let you go ahead and do it.
Where you, I don't know. The planning director mentioned that the subway could see the engine repairs from the subway, which I think is, kind of far-fetched. Any engine repairs would be done inside of the shop. So unless you have x-ray vision,
Right.
you can see the engine repairs from the shop.
Yeah.
That's all I wanted to mention. Thank
Okay.
you.
All right, thank you. And so we'll leave any additional comments during public comments at that time. So making sure, now I want to make sure Councilwoman Hood has a chance.
Yes, thank you. I just want to ask about the noise. It sounds like the repair work is being done inside. Can you give me a sense of what the noise level might be for the restaurant next door? Is this something that's going to disturb people eating?
So wait, first I need to understand, who are you directing the question?
To, I guess, staff and the applicant.
Okay, so first I'm gonna let Mr. Richards come, and then we'll go from there.
Yes, so based on staff knowledge of basic car care, an oil change and just testing for emissions, that's very little sound, very little disturbance. So the only noise they have now would be tire changing, which is quite noisy as well. But once you do start putting in other equipment to fix and pull out engines and all the sounds that come with that, I think it does increase the sound they'll be emitting from this building, who typically has all 4 doors open during hours of operation, so the sound is vibrating outside of the building quite easily.
And I'm gonna interject on this piece, because a tire sounds a lot louder than an engine being hauled out, right? And so I think for us really having this conversation, we need to have the subway involved, because we're doing a lot of conversation about what if this, that, and we don't have them as part of this conversation. And so it's kind of unfair to you doing it in terms of making some of these decisions. If we're just gonna make the decision off of what we have, that's one thing. But if you're saying a lot of it is based on the subway, it's kind of unfair, right? Because you can't see them changing the engine the way it's located. The store is kind of curved this way, so you can't see from the brick wall that's next to where his shop is. The glass is facing the front and on the right side, correct?
Yes, ma'am.
All right, okay. So I'll go back in terms of addressing your question, and what I want you as the owner and the applicant is just kind of write down or think about all these pieces. I'm going to allow you a chance to come back and speak, but I don't want this going back and forth. So if you just listen to what we're saying as a council, and then after we've spoken, you can have another chance, okay? Okay. Vice Mayor.
I got a question because I know you said we were not gonna drag this on, but I just need one of them. You can. I need one of the owners to tell me if that same equipment that is gonna be used to change that tire is gonna be used to take those nuts and bolts off of a transmission. It's the same equipment. Am I correct? So if you can hear it changing a tire, that's about as loud as it's gonna get because the same tool is gonna be inside now changing the transmission. I get it. That's what I'm trying to say. Outside, you're gonna hear it more. But inside, it's just a zip, zip, zip. Okay, gotcha. Thank you. I needed to understand. Thank you.
And Councilwoman Hood, did that address your question?
Somewhat. I would hope that we could, as you say, maybe get the input from the adjacent business and figure out if it's noisy now. We don't want to add to the noise, even at the same level. So that's just my concern.
Okay. Yeah. You had a question, City Manager?
I just want to ask a question for clarification to Mr. Edwards. Does the code currently provide for a full-fledged auto repair shop?
It does, and it's only in the light industrial zoning districts that would be allowed by right.
Is this particular property in that district?
No, it is not. This property, I believe, is zoned NC2.
Okay. So technically, if we allow for conditions within this district that are currently not provided in this district, right? We are going against the current zone code to allow for conditions that are not allowed within that zone.
Yes, ma'am, I would think it would be against the current zoning code and the current comprehensive plan.
So
Yes,
I want to interject, City Manager, if you don't mind. That particular area was annexed back in 2015. So that property was functioning within the respective code. And so that's where, in terms of what he was doing, that's where the code, in terms of the zoning portion of it.
Okay, that helps me. I'm also trying to get to how we got to where we are now. So if that particular property was already functioning when the property was annexed, and I guess would typically have a grandfather type status. At some point, the status.
Yes, ma'am, I think I can answer your question on that.
Thank you.
Okay.
So in 2020, the city council voted to limit them just to oil changes, emissions, and tire repair for the conditional use permit to allow them to sell cars on the property too.
Right.
So if they hadn't wanted to sell cars on the property, they could have maintained as a full-service auto shop.
Thank you.
But since they got the additional use on the property, city council did restrict the full use of the property.
Thank you.
And Councilman Perkins, did you have a question?
Reformulating it.
Okay.
So I kind of hear about maybe three different components to this. The first, just to make sure I'm clear, Mr. Edwards, is we're having kind of two different conversations. One is expanding the parking, and then one is expanding the services offered. Correct?
Yes, sir.
Okay. In the discussions with planning and zoning, has there been anything proposed to upgrade the facilities or maybe create some barriers between the two different properties that are in conflict? Is that something that the applicant is willing to do?
That conversation has not been had with the applicant on the buffers or anything like that. But looking at this side, it would be very hard to put buffers between what looks to be about a 10-foot buffer that's all concrete there between them and the subway.
But in my understanding is that, I mean, there's the noise issue, which I'm also concerned about because there's residential right behind there. I could see there being some conflict over parking spaces, and that to me seems like if they'd have to go and look at the details, could be a simpler solution of just putting in a curb versus I'm not thinking like visual buffers. That would be a different conversation. My other question is, and this sounds a little bit like the conversation needs to be more of a conversation around a zoning change than necessarily a conditional use permit per our city manager's questions.
Yes, and to clarify, this getting the modification to this CUP was actually an order from our municipal judge
Okay.
based on code compliance issues.
Can you unpack that a little bit for me?
It's still active in our municipal court, so I can't really speak to the matter. But I think from my research back as far as 2017, there was just a lot of code compliance cases around the same topics. And the judge is asking the applicant here, Mr. Dine, to come through and either get those fixed through zoning or that the CUP would have to be obliterated and they would no longer be allowed to sell cars on the site.
Okay.
So I remember this conversation very well as I sit in the same seat in 2020. And the reason that we even approved the cup was because, Mr. Barber, how were you operating back then? What did you want? How did you want to operate? Right. You wanted to be a broker then?
Yes.
Correct.
Yeah.
So you want to sell cars.
Yes.
And now you want to go back to...
No, now what they say, they changed that time, that was full service. They changed, they said only you can do oil change and the emission on and tires. I cannot do the brake change, I cannot do the dynamics of the engine.
Sorry, Mr. Bravo, can you speak to the microphone
Well,
so we have it
sorry,
audible?
Mr. Councilman Perkins. Wait, and then, because we're not going to do it back and forth. So ask your question, Councilwoman Bell.
How do you want to operate?
And so go ahead and I'll have you to go up.
Because I remember this verbatim.
We want to operate by what our building has the capacity to be able to do and what we are equipped for. We are well equipped for the sale of autos, and we are well equipped for the full service of vehicles without any concerns, many major concerns for environmental. And you mentioned the subway thing. We could very well put a buffer between us and subway, but I don't think that would be very convenient for them.
So let me ask you another question another way. Based off your paperwork that you have, are you a broker?
Not sales. I changed my license. It's been changed a long time ago.
But you changed it to a broker so that you can sell cars, correct?
Yes.
And do you have currently your documentation and your paperwork allows you to be a full service auto repair shop? Because this was the issue in 2020. I remember very well. Don't take me to look click.
Yes.
And I remember you wanted one distinction or the other. And at that time, you wanted to sell vehicles, and that's why we moved forward with the code. So I'm going to ask you this question again. Based off your documentation, what can you do? Can you be a broker solely, or do you have documentation that has been filed by the state that allows you to fully repair cars?
I guess.
You have both. Okay.
Okay. Okay,
Thank you.
thank you. Any questions?
I think that it would be good on the part of the city to get an in-depth review of how and what led to the original conditional use permit. Because I do remember that it was something that the council did at the request of the owner. And I believe Councilmember Bell is correct. And so whatever reason we had to make those decisions, or council made those decisions at that time, I think we should be aware of that, and then we can better understand what course of action we can or should take going forward. And so if that can be done, I don't think that can be done tonight. Perhaps it can be done before the meeting next week.
Right, and I'm going to defer to our city attorney who has that institutional knowledge as it relates to where we are here.
Yes. you know, I don't have a perfect memory of every decision we make, but I do recall this one being, I recall it the same way that Mr. Edwards described it, which was that there was an ongoing auto repair, using that term very broadly, business that wanted approval for to be an auto broker, to sell cars. So that's what that was all about. I noticed that we have in our packet here the minutes from that meeting, and I was just starting to read those and see if that is illuminating.
I remember it as well. It was an application. It was basically a trade-off. He was moving from industrial to NC2, so he could be a broker.
Mm-hmm.
And the trade-off was no repairs, not the full repairs, in exchange for the broker. Was basically the deal.
Okay.
So.
Okay. So with that, do we have any other questions from the council at this time? I'm going to allow the public at this time to speak. So did we have anyone, Clerk Mitchell, do we have anyone signed up to speak?
Yes. Diane Abdul. Yeah,
Okay, all right. And then who's the next person?
Suleiman Mohammed. Please forgive me if I mispronounce your name.
Did you want to speak? No, ma'am. Okay, all right, who's the next person?
Mohammed.
Okay, that's you already spoken.
Ugo Injanaya.
Okay.
Daris Mazia.
Is that?
Okay.
No. That's it? Okay. All right. Mr. Dean.
I apologize for getting here late, but I would like to sign up and add my name to the list. Dean Moore, Rayford Trail.
Mm-hmm.
This situation is clearly he's doing well. He's been cited for different violations that apparently were only taking place during the day or was misperception by code enforcement. We've long had issues with code enforcement being around only during certain hours of the day and not being around at night when they could actually verify what his parking spaces were used for over the course of the evening. So I think that should go in his advantage. And I also think that giving somebody the ability to sell only 5 cars sounds like you want to dip your toes into the water to see what the temperature is. He's been doing well. He wants to expand it, and he's got the capacity to do it. And the buffer between the subway, like was pointed out by the vice mayor, that there's a brick wall. They can't see it, that it's not really impacting the subway at all. And if we brought them in here, they'd probably tell you the same thing. And we all know what it sounds like when they're running their pneumatic drills and it's cranking up and it reaches its point of impact. And it makes a bit of racket, but you know, that's like a 4.5 lane or 5 lane highway there that there's all kinds of noises there all the time. This is more or less an industrial area as far as that is concerned, although there are several apartments there. But there's not anybody who's staying awake during the day or complaining about the noise from this place. He's been doing business for a number of years. He wants to increase his business and his capacity, and I think it's a good idea for the council to allow that.
Okay, thank you. Any other? Yes.
Just looking back over these minutes from 2020, I think that Councilman Carroll said this, but it bears repeating. This property was zoned light industrial, which allows for the full auto repair use that's being requested tonight. But at that time, the applicant requested rezoning from industrial to NC2 because that allowed, with a conditional use, the auto sales, which were not allowed in industrial. So we've apparently come full circle, except for that there's now basically a request to do both.
So based on that request to do both, what is kind of your legal opinion for that?
I mean, speaking conceptually and not about this applicant, my opinion is that putting, what's the way to say this? The conditions of zoning are not the appropriate way to change the allowed uses on a parcel. The right way to do that is by rezoning.
Okay. All right, and if we did rezone it, the concern is it wouldn't allow him to, he'd have to make a choice.
It seems that way.
Unless you change the zoning categories, right?
Yeah.
Right.
You could rezone and say in industrial, you can sell cars, and that would,
Right.
fix it. But you couldn't just do a pure rezoning. You're right.
Right. Okay.
Excuse me.
Yeah.
so,
With that.
Yes, and city manager.
uh,
I want a city manager, then Councilwoman Hood.
Thank you. So just so I understand, that will require a rezone and a text amendment, potentially?
Yes, right. You'd have to amend one of the two zoning districts.
That's correct.
To include a permitted or conditional use that's currently excluded from that district.
That's
So
correct.
it could be just a text amendment and not a rezoning. Like, for instance, if the text amendment made auto repair permitted or conditional use in the current zoning district, then they wouldn't need to rezone.
Right. And that would apply, that particular text amendment would apply to any property within that district.
Right. And I think that I'm not an expert on zoning. I'd let Mr. Edwards say, but it seems to me that allowing the auto sales in industrial would be a lot more palatable than allowing the auto repair in our neighborhood commercial.
Yes,
Yep.
sir. Thank you. And that was really the point of my previous question.
Right, thank you. And then Councilwoman Hood.
That's exactly what I was going to ask.
Okay. And did anybody else want to make a comment publicly over any more?
Well, I guess, Mr. Edward, this is a question for you. Based off our, that's an old map. That's an old map? Yeah. Based on how our zoning is currently set forth, then that means that hypothetically, if there was a text amendment that allowed it, it would be a button NC1, NC2. No, he's in NC2, but it connects to in R1.
In our CD.
In our city?
There's
No.
other areas that have it.
Yeah, so it would be in our CD behind him here. So this is his red property right here on the corner there.
Yeah.
So he would beside NC2 and NC2 across the street, but all the brown around is NRCD.
But we do have NR1 abutting NC2 and other areas of the city, which if we were to go the text amendment route to the NC2, that would apply to everybody. Which I don't think is.
I don't think that's what we want to do in terms of that.
But it could be a conditional use
But that's how we got here.
within
Right.
that zoning.
So I mean, one way, it sounds like the first thing that needs to happen regardless would be a text amendment to whatever desired zoning district, and then a reapplication or an application to rezone to that zoning district. And so, for example, we could do a text amendment setting brokerages and repair shops is permissible use in all of light industrial, or we could set them as conditional uses in light industrial, just depending on how much oversight or how many checks and balances we wanted. But my understanding, and correct me if I'm wrong, Mr. Quinn, is that that's, we want to do things by the book. Whatever route we take is the next thing would be a text amendment. And let me add one more question to that before you answer too. Could we do, if we wanted to open it up for an application to rezone at the same time, could those two things happen concurrently, or would it be better to push one through a cycle and then once the change happens?
So to answer the second question first, it would be fine to do those on the same agenda.
Okay.
And the first question, and now I forgot the first question. was,
Just the order of operations.
Right.
So text amendment.
right. So,
becomes-
I mean, the text amendment would, of course, apply to the entire district. You could start the process for the text amendment, and the applicant could start their process for the rezoning at the same time. They could move through the process at the same time. That's not an issue.
Okay.
So
And
then
Madam
it
Mayor,
sounds like to you, go
I have
ahead.
one more thing, if I may.
Mhm.
So I think the other thing that we want to consider is the long-term direction of the city too with this. And I know there's been a lot of conversations on redeveloping areas of Brockett Road. There's been a lot of requests for green space and additional amenities there. And so I'm not saying this is, one way or another on this particular issue, but I think it's a consideration that we need to take very seriously as we think through whatever our plan is, whatever direction we take. Especially we don't want applicant to go through a whole lot more money and time heading in a direction that we're not going to go in. Is making sure that we keep in mind the comprehensive plan and the comprehensive plan update that we're coming through, and requests that we've already had from constituents in that area of what they would like to see on that corridor.
Mayor,
Okay. Yes.
I would suggest that we ask Richard to work through all of the discussions we've had about zoning change or text amendment or having it be a conditional use in certain districts. And if you can advise us on what you think in working with the city attorney, what is the best approach to deal with this situation?
So to that point, I want to make sure we have consensus for staff, for the city manager to direct staff to do that, because that's going to, take him a little more time, I think, more so than by Thursday, correct?
Yes, ma'am.
Okay. And so making sure we understand the difference between, again, the text amendment, what that would look like from a zoning change, and then the steps that we would have to go through. Is that what you wanted to hear in tandem with working with the city attorney?
I think I could have you a general idea of how it should run, and not even best options. I'll give you all the options on the table, just so that we're all aware of all the options. Working with the city attorney, we can have that to you by Thursday. I don't think that's a problem.
Right.
Okay.
But we wouldn't be able to make those decisions because
Yes.
that's not what's gone through the
Yes.
zoning process.
Right.
Yeah.
And then the last thing I wanted to add is, this is just sort of a note for the applicant and for Mr. Edwards to speak with them about between now and next Thursday is how do they want to dispose of this application if we're going to take that other path, because I believe it might be to their advantage to withdraw the application.
Right.
Yeah.
Yeah.
Yes, it would.
Yeah.
Because legally, we really can't change the use in a zoning district through a CUP, right?
I agree. At least
Right.
we should not.
We should not.
And yes, I agree.
Okay. So does that work in terms of, right now, we can wait till Thursday? But it sounds like for the applicant, as we're going through this, it may make sense for the applicant to consider withdrawing after you've had a chance to review for yourself, because that's your decision to make, right? But you're hearing our deliberation, okay? But ultimately, it is your decision to make, okay? But we're expecting the city manager to instruct staff to take what makes sense in terms of text amendment versus the zoning. Is that fine for everyone?
Yes, ma'am.
Okay.
Yes, that's fine. However, Mr. Barber, you know what I'm about to ask you, right? What am I going to ask you? You need to contact Subway. This was the biggest challenge, and he know it just like I do. No matter what he decides, no matter what we decide, there was a halt. Okay?
Okay. All right. Thank you. So we'll move on to the next one. Okay? Thank you all. And then the next agenda item is to discuss a request for Clemsell overlay development review for a single-family home at 3637 Lincoln Street. And Ms. Dean, if you wanted your photos, I'll also have that for Lincoln Street or 1212 Pat Davis Drive. And Mr. Edwards.
All right, thank you, Mayor and Council. So this here is just an application for a development review for a single-family home that's one story in the Clemson Overlay District, as our code does require any development in Clemson to come through you all for approval. And the property at 3637 Lincoln Street or 1212 Patricia Davis Drive is currently a vacant parcel within the historic Clemson neighborhood. The applicant is proposing a one-story single-family home on a stucco veneer over concrete block foundation. And in your packet, I went through all the zoning conditions they would need to meet, and it does appear they meet or exceed all of those requirements. And on this, staff is recommending approval with the following conditions. One, the site plan shall be developed substantially in conformance with the site plan dated June 17th, 2025. And two, the architectural elevations shall be substantially similar to the elevations dated May 21st, 25. And with that, I will turn it back over to you, Mayor.
Okay, thank you. And I think one of the conditions or concerns was that the applicant have a door facing the street. Concern. Yeah, concern. So,
Yes,
not in.
ma'am. I know several members from the Clemson neighborhood have spoken with the applicant, and I do believe they have agreed to do an on-slab development with putting in a front porch on the development to make it more in line with the neighboring properties.
Okay, if they're doing that, what does that do in terms of the actual application that we have now?
So if that is the case, we would ask that this application go back to the Planning and Zoning Commission for a review before coming back to you all for a vote.
Okay, is the applicant here?
I'm not sure.
Okay, is the applicant? Nope. Okay.
I informed you about the meeting as late as yesterday morning, so I'm not sure. I'll get with Mr. Dramer tomorrow to confirm that, and I'll also work with the property owner, Mr. Aguilera, to make sure he's aware of the changes as well.
Okay. Until then, I guess we want to make sure that if he's willing to do that and we have something in writing from that, then we can proceed in terms of deferring it to go back to planning and zoning. But until that time, we want to make sure we wait it. Council, do you have any questions at this time? Okay, we'll defer this one until the next council meeting where you can inform us if that's fine with the developer, and then we can make a vote from there. Is that good?
Sorry, point of it. If this is an application, are we not obligated to do it? I think we have to make a vote on it at our council meeting, correct? Unless they withdraw the
Right,
application.
at the council meeting, but we need to find out if the applicant is going to make the changes that the staff just discussed.
Mm-hmm. So when you said, sorry, I heard defer to the next council meeting. You're just saying
To next week.
next week. Okay,
Next week,
gotcha.
yes.
That's what was for my question.
Okay, so I'm gonna
Go
let
ahead,
Vice
Deborah.
Mayor and then.
Okay, well, I took the liberty of speaking with the owner, and the community had a problem because we did some research, we being Clemson, and there's not a house in the state of Georgia that does not have a front door facing the street. So I reached out to the owner, and he has agreed to put a front door on the house, to use the right side porch and deck to extend the master bedroom, so that, because he said that's really what he wanted in the first place, but he was under the impression he had to use the crawl space method to build a house. With the crawl space, it elevates the house, then the porch is extended, then there's stairs, and it's gonna encroach in his setbacks. So it's gonna be more beneficial for him to do it on a slab. So he was willing to work with the neighborhood for the aesthetics of this house. All of his setbacks and everything according to the site maps and layouts were wonderful. It was just the aesthetics with the front door. So he said that it's new to him, this whole process, because he came to us in February wanting a 2-story house that did not line up with the Clemson overlay. So he asked that we can give him until August the 7th to submit the updated information to planning and zoning. Mr. Edwards should be getting that information, but it has to go through every cycle of creation. So that's where we are right now. He is currently either on his way out of the country or out of the country until August, but he is working on it.
Okay.
But it benefits the owner to change the development. So that's why it was sounding like a deferment, but not a deferment.
Okay.
To the next council meeting. So after speaking with the city attorney, any changes outside of these documents that you have in front of you would have to go back to planning and zoning because there are architectural changes, potentially architectural changes. So there we are.
Okay.
Thank
Councilman Carroll?
So this is kind of a little bit broader comment, but my suggestion is that we get the Clemson regulations the way we want them, whether that's requiring front doors or front porches, whatever it is, and then just let these be auto-approved by staff if they meet the conditions. Because I think having the council go to approve every single permit is really going to add a lot of time and delay in the process. And if they meet the Clemson conditions, I think they should just get their permit.
Well, there are some things that have been talked over with the planning and zoning director, but that wasn't one of them.
Okay.
This community would like to preserve the right to actually see these things before they go into effect. Although it's new, some of the processes were not followed during this process in the first place because no one 350 feet, or is it feet? Yeah, we're not notified of this development, that it was even going to planning and zoning, that they were willing to overlook that because it was new. So that part of Clemson is not up for negotiation, but there are some things that have been recommended by planning and zoning to be updated so that all of their, it says door, porch, and stoop, but it doesn't say front. So all of that will go through a text amendment at a later date. We're not going to interrupt his development with any of that, so.
Right. I just think administratively, if every single permit we have to approve, that's going to add a huge amount of delay to the process, and that's not really our role. I think our role is to set out guidelines. If you meet the guidelines, you get your permit, and if we want to change the guidelines to say you have to have front door, front stoop, whatever, that's fine. I just don't think we should say, okay, you met these guidelines, but then you still have to go through the council approval process.
Okay. Thank you for noting that. Any other comments?
So I still want to make sure I'm clear. So deferral has a specific meaning in terms of, our procedures. And I'm a little uncomfortable deferring an application without the applicant themselves withdrawing it or requesting that. So, Mr. Quinn, I saw your hand was raised. It sounds like you've got.
It's not a deferral.
Right.
We're gonna do what we're gonna do on the 7th because it's recommended for approval, unless you want to see something different.
I don't have a strong opinion on that one way or the other, just
Right.
making sure that we do right by the applicant and follow our own procedures. So, Mr. Quinn, did you have a?
Well, my understanding is that the plans that were presented to the Planning and Zoning Board
Different.
are substantially different from what we're talking about approving.
Right.
And since, as the Vice Mayor just discussed, like that architectural look is a big part of what is being approved here,
That's correct.
then I think this needs to go back to the Planning and Zoning Board for a public hearing on the plans that they want approved. And because otherwise that would have essentially been a skipped step, right? It would be like they showed one thing to planning and zoning and then got a different thing approved.
Right.
So my recommendation would be that the applicant would withdraw their application. If they can't be reached because of traveling, then the council could defer it to give them an opportunity to do that. But what would need to happen to go forward based on the conversation tonight would be a new substitute application.
Right.
City could waive the fee, basically apply the fee that had already been paid, put the public notices in place, and then come back through the process.
Okay.
Question
So-
for the city attorney, Madam Mayor.
Yes.
Without that documentation being already submitted or confirmed by the planning and zoning director, do we want to do that? Or are we
Which-
just asking the planning and zoning director to make that contact?
Were you asking about the withdrawal
Right.
aspect? Yeah, I wouldn't do that for them. That's why I said
Right.
if they can't get in touch between now and next Thursday,
Then we
then
can
I would
defer.
recommend deferring
Gotcha.
it to give
Right.
that opportunity. That should be the applicant's choice.
Right.
All
So
right.
that was the piece in terms of
Clarification.
the staff working with the applicant to confirm in writing that that's what they're willing to do, because we don't have anything in writing to confirm that they're going to go totally different from what was approved from planning and zoning. So once we have that, then the applicant can withdraw their application and then go back through the cycle in terms of going to planning and zoning. Correct?
Exactly.
Correct.
Okay, thank you. Yes, and I'm gonna let Mr. Edwards
So
speak.
staff did get an update at like 1:30 this afternoon, so we didn't have time to find the plan to get in contact. And if I may, City Attorney, would it be possible if we can't reach him to deny this application without prejudice, which would allow them to resubmit?
Yes, that'd be
And then-
another option.
Okay.
It'd just be part of the motion at the time that the council acted.
Okay.
Okay.
Yes.
I had one more procedural question too. So would it change the process of them needing to go back and resubmit a full application to council? So in section 204 of the zoning procedures, it's, let's see, or sorry, 205 6, it says the mayor and city council shall hear the application at their next meeting which complies with SCGA, as it now exists or may be amended hereafter. So does that create some wiggle room where we could see some modified plans or?
No.
No, I don't think so. I believe that as modified after would be the state of Georgia's legislature changing the zoning procedures law.
Gotcha.
Right.
Okay.
Thank you. Any questions?
Well, I just want to make sure I'm clear. Because you got the updated design today around 1 or something. Is that correct?
I got a verbal confirmation from community members who were in touch with the property owner.
Okay.
I have not seen any plans and I have not directly spoken with the property owner at this point.
So we should keep this on the agenda as is until we get some direction or change that have been withdrawn, and then we'll move forward, whatever that is.
Yeah,
Y'all
that's
agree with that?
that's what we were saying, and
That's
if
where we were.
he gets it in between, then
I just want to make it clear.
yes.
Saying like, we get all clear.
Well, we'll make it clear right now. So it stays as is. City manager will instruct staff to get written confirmation. Once we receive that written confirmation, if it's different design and they're willing to do that, then he will withdraw. Otherwise, if we can't get a hold of him, then we have the option of deny
Without
Well,
prejudice.
without prejudice. Okay. Is that clear?
I got a sub question. Do we need written confirmation or do we need a new design that illustrates the changes that they're confirming? Steven.
That's step 1 and then step 2. So we need both, right?
Okay.
Step 1 is to eliminate this application. Step 2 is to get the design for the new application.
Thank you. I think we're clear now.
Okay. All right. Now we'll have public comments. Anyone from the public wanting to speak on this particular item?
I have Mega Romani.
Okay. All right. Do we have anyone else? Okay. Hearing none, we'll close out public comments and then we'll just have this as is right now on the agenda. Okay. Now we'll move to item E, which is to discuss a request for variances from section 305 to reduce minimum lot width and section 540A to not require a 5-foot sidewalk at 911, 917, 929, and 935 Mill Avenue. Mr. Edwards.
All right, thank you, Mayor and Council. So on this one, it's 911, 917, 929, and 935 Mill Avenue, and they're looking to reduce the lot widths from 50 feet to 36 feet for 10 lots and to 30 feet for 3 of the lots, and a variance request to not have the 5-foot sidewalk. So on this one, it appears that they meet all the rest of the zoning code requirements except the lot width requirements. And so the applicant has requested for the lot width reductions in an effort to keep the development in line with the existing single-family neighborhood. The Planning and Zoning Board decision was based on public comments that all supported the lot width reduction and being in line with the existing development along Mel. And these properties, and so it's for the 13 single-family homes on this lot, which is, single-family homes are allowed in the NR3 zoning district, but they do have the larger lot width requirements. So on this property, they could do the 13 townhomes as proposed, but also townhomes are allowed by right in this district. And this conversation came up quite a bit at Planning Commission, so I added some numbers in here for you all to consider before making your decision. So at approximately 2.07 acres in the NR3 zoning district, with a floor area ratio of 0.4, they could potentially construct 22 townhomes at 1,600 square feet or 18 townhomes at 2,000 square feet. This is based on the highest number possible. It's not based on a full engineered plan. So those are hypothetical numbers, but they should be in the general ballpark of what could be constructed there. And also on this one, after more research and after the deadline for this meeting, it was determined that 905 was still zoned NC1. So that project is going through as a rezoning and a concurrent variance for our next cycle. As the property owner who still owns the property has requested that change for this buyer, any potential buyers in the future. But with that, this applicant who is under contract for the properties has decided to proceed with this to see if they could still get the single family homes as opposed to doing townhomes. And with that, staff recommends denial of both variance requests. And then the Planning Commission recommended approval of the variance request from Section 305 to reduce the minimum lot width from 50 feet to 36 feet for 10 lots and 30 feet for 3 lots. And further, the Planning and Zoning Board recommended denial of the request from Section 540A to not require a 5-foot sidewalk along a local street. And the conditions Planning and Zoning Commission recommended was 1, the development shall be substantially in compliance with the site plan dated April 10th, 2025. 2, the development shall be substantially in compliance with the architectural elevations Newberry Plan dated November 11th, 2024, and Rosemont Plan dated August 8th. And 3, a rezoning to NR3 and a variance from Section 305 to reduce the minimum lot width shall be obtained for 905 Mel Avenue by the applicant prior to any development of these parcels. And with that, I will turn it back over to you, Mayor.
Okay, thank you. And do we have the applicant here who want to speak? And state your name.
And there is her presentation you have on your dais as well.
Okay.
Hello, everyone. My name is Mega. Can everybody see the presentation? Oh, there it is. Okay. So my name is Mega, and I'm from Altair Developments. This is my partner, Josh, right here. We're a medium-sized builder that builds single-family homes and townhomes around the city of Atlanta and DeKalb County. We would love to bring this development to city of Clarkston. We are here to present this development in 911, 917, 929, 935 Mill Avenue. And what we are proposing are 13 single-family homes on this land. If we can go to the next slide, please. And the next slide, please. So what you see is this parcel of land. It is a very large parcel of land that you see. And what we are, like I said, what we are proposing are 13 single-family homes. And if we go to the next slide, we'll show you what type of homes that we want to bring in this community. This is our Newberry plan that varies between 3 and 4 bedroom plans. And there's a second plan, the Rosemont plan, that we plan to build on the 30 feet wide lot. If we can go to that next slide, please. That Rosemont plan. So these are the 2 plans that we're trying to build in this 13 single family home community. And we've done our homework enough with the community and neighbors to propose single family homes instead of townhomes, although that brings us as builders density, because that's what's best suited for the neighborhood, and it's an already established neighborhood. We had very strong comments from neighbors, and that is why we are proposing single family homes instead of townhomes. As builders, we just want to show you all what kind of finishes that we offer. So if we can go to the next slide. We offer high-end finishes in our homes, like our countertops are quartz. Our standard ceiling height is 10 feet. We put all of our kitchen cabinets all the way up to the ceiling. We use hardwood floors and do spray foam insulation for homeowners to have a smaller power bill. What we're basically saying is that we do provide higher end homes, but within a very lower price point than our competitors. So we're a very unique builder group that we provide those high end finishes, but we keep our price points low. What we are asking for here are two variances, and if we can go to the next slide, please. This is the plan that you see where there are 13 lots here. 10 of these are sized 36 feet, and 3 of these are sized 30 feet. So what we are asking here is two variances. First one requesting 10 single-family homes with the minimum lot width requirement reduced from 50 to 36, and 3 single-family homes with lot width requirements reduced from 50 to 30. Now, while we are asking for the width requirement, please note that the zoning code says the lot width should be 50 and the length should be 100. But our lengths are 200, which is double the size that we're offering. So even though we're reducing 14 feet from the width, we are adding 100 feet to their length in the back. So that's what I want to highlight over here, why we're asking for this. What this means is that a standard 50 by 100 home is 5,000 square feet in terms of land. And even with these lot widths that we are proposing as variance, we are providing 7,200 and 6,000 square feet, respectively, for the 36 and 30 feet. Second one, the variance that we're requesting is to remove the sidewalk requirements completely because this is an already established neighborhood. There's no other homes with sidewalks, so that is why we're asking for this variance. We would love to build this development in the city of Clarkston, and that would be a request for this.
Thank you. Council, at this time, do you have any questions? Yes, Councilwoman Hood.
I have questions for Richard, please. Thank you. Mr. Edwards, how many houses could go on this property without these variances?
Let me grab this. The applicant's saying 9 based on the length, and I believe that would be about right based on a 50-foot lot width.
So it's about 450 feet, linear feet.
I believe so, yes.
So that divided by 450 divided by 50. Okay.
So 9.
9.
That's your question?
Yes. Is there a particular concern about going from a 50-foot width, which is the minimum, to 30? I mean, that's almost a 50-foot. I mean, can they meet the side setbacks and?
Yeah, based on the way they've got it laid out here, they do meet all the setbacks. Yes, ma'am.
You know, everything in that neighborhood is 50 and 100-foot lots. So these are single-family homes, but they're not consistent with the neighborhood.
Yeah, and staff's recommendation is denial on both because we did not find that it met the definition of a hardship in our zoning code. However, the applicant has stated that based on conversations with the neighborhood, based on cases that have come through recently, that they want single-family homes, so they have decided to proceed with this request to you all.
Right. So even though it does not meet technically, there's no hardship here. There's nothing unique about the property. The neighborhood is supporting it because they don't want townhomes.
That is my understanding. I would not like to speak for them.
Okay.
I mean, that's what it sounds like.
Okay.
Yeah, I have a question for the applicant, if that's okay, or?
Okay.
Yes, have you thought about doing something like a planned residential development where you would have an interior street and having houses along that. I don't know if that'd be more palatable to the neighborhood. I know the townhouses would not be.
Yes, ma'am. And those planning units do require an HOA. We're talking about a development without an HOA, and that was one of the concerns of the neighbors, that we've seen history with this lot, and we've heard a lot of history with this lot, and we wanted to propose something that all the community and the neighbors are, to the liking of this, and it's already an established neighborhood. So I'll let my partner answer this too.
Yeah. So I'm the general contractor. So what I think she's also referencing is that I know that Tracy doesn't like me to get to numbers, but if you're talking about the price point of the property itself, so you have the price of the property itself, and then you're talking about development on top of that. So you have another community that's very similar to kind of what you're referencing, going ahead and putting in a private street. They're for sale. They're $500,000, and they're not selling for the most part. No, I'm not. They're the builders here. I don't mean to be negative, but my concern with those homes, I guess, is what I'm trying to say is that you don't really have a front nor backyard, and so what you're doing is you're congesting the property. You're getting maybe you are getting like 15, let's say 16 homes in there, but they have no real front yard, no real backyard. And then the development cost of it is actually going to increase the price of the home. What we've always tried to do with our properties is that we try to provide high-end finishes, and we're trying to, at the end of the day, provide value to the actual consumer. And so what they would want is a big backyard, some high-end finishes, and keep you at $400,000. And I'm saying, we can't guarantee that, but that's always the goal and the objective. If you put in a private street, you're going to create an HOA, which is going to increase their monthly payment about $250 a month. And then on top of that, the actual development on top of the price of the land is going to ensure that house is $500,000.
And you're saying about $400,000 is what you would be marketing out?
What we normally do historically. And so we're the builder that builds those on those 25-foot wide lots in Scottdale. So we do those. Those are 3 stories actually. So this is only a 2-story. Those Scottdale lots are 25 by 100, and so that's why you do 3 stories there. For us, because we have the length, we make it 2-story and add it. And the more narrow lots are about 50 feet in depth. So yeah, we're getting about 1,600 square feet, maybe 8. Well, the larger house will be about 1,900 square feet, so 1,600 and 1,900. And we try to stick between about 375 all the way up to about, at most, like I said, about 450. I would prefer to stick at 400, just because my concern, and this is irrelevant to us, and I get that, but I am concerned about affordability. I know that every builder says affordability, but the most buyers do not have a lot of money, and I think we all need to recognize that. You can talk about taxes or whatever. It's a political debate, but I can guarantee you from what I see that all my buyers now are 50, 40 years old. I rarely get someone who's 25, if ever. We need to focus on affordability. I mean, that's kind of, and putting in a private,
All right, thank you for that. Thank you for considering affordability, and thank you for working with the neighborhood.
Okay. City manager? Yes, ma'am. I would like to say, I definitely agree that we have to consider affordability. I think the way to approach that is to implement policy, right, that considers that on the front end, rather than approving or considering the approval of variances that don't meet the requirements in a code, right? For any particular development, if you go against the requirements for this variance and you approve it, but you uphold the requirements of another variance application, then I believe that doesn't set good precedent for the decision making of the body. So we talk a lot about affordability, which is very important, right? But we need to think about that from a policy perspective as opposed to implementing decisions that go against that policy.
Thank you. Councilman Carroll.
So I have a question. So supposing the council, I don't have a crystal ball, so I don't know what's going to happen, but supposing the council didn't grant this variance request, would you do the 22 townhomes or the 9 family homes? Have you not made that decision yet? Or
Yeah, ultimately we would do the townhomes, because even though there's an HOA implemented, the monthly payment would come out to be about the same. And so My biggest concern is the ultimate buyer's monthly payment, because that's really going to be their deciding factor. So for us, you might be able to offer like a townhouse for, let's say, 300, maybe 325, but with the extra additional cost of like HOA fees and stuff, you're going to be right about at the 400 for a single family. So it's comparable.
So it'd just be 22 townhomes, the lower sticker price, but then when you add the HOA, it'd be a similar monthly payment.
Monthly payment's going to be the same.
Mm-hmm.
Yeah.
Okay, that answers my question.
Okay, thank you. Any other questions from the council? Okay, the public at this time. First, do we have anyone signed up? Nope. All right, Dean.
Dean Moore, Rayford Trail. On the subject of sidewalks, they really do add to the community from infancy to elderly uses. I mentioned in the planning and zoning on this that they could use the sidewalk for hopscotch, and everybody laughed at my suggestion. But this place is on a hill. You could have sledding. As people do age and have strokes or any other infirmities, they have a safe place to walk to get their exercise, even if it's only for 13 houses or 22 houses or whatever. That's still a big addition to the value of that property for those people from cradle to grave. So I think that in the one case recently, you allowed a house to be built without a sidewalk, hoping to have a plan in place that if you give that advantage to somebody to eliminate that from the community, that they would pay into a bank that would help pay for sidewalks in other areas or an account of some sort for sidewalks in other parts of the area. This is eliminating at least 13 homes that could have a sidewalk, and those together would help build community for different events even within that community. And so I encourage you to not allow the denial of or the requirement of building a sidewalk in these new houses.
So I want to make sure I'm clear. You're wanting us to, if we move forward with this, to make sure that we include sidewalks.
Yes, absolutely.
Okay, I just want to get clarity. Yes, and state your name.
Tracy Minnick, and I guess I'm attached to 814 South Jolly Street, Clarkston. My question was, the last time I was here, there was no definition of a townhome community or the square footage you were allowed. Has that been clarified since he was able to quote the amount? Has that been amended in the NRC? What you could build multifamily townhomes on? Because when I came to the last meeting, there was no definition of the townhome requirements. Where did Richard go?
Yeah. So right now we don't have.
What's the square footage now?
So there has not been an official text
Yeah.
amendment that delineates townhomes from a multifamily building. However, the way it would work is the townhomes would be constructed as a multifamily with a single family occupancy of each unit.
Okay. So long story short, I was proposing the single family because it seemed too complicated within Clarkston's guidelines at this time to try to do a townhome, but I also feel like it's in the best interest of the neighborhood. I've toured all the townhome communities in Clarkston, and a lot of them are not being properly maintained, and the HOAs are not doing their jobs. I feel like a single family homeowner occupant is going to maintain that property substantially better than an HOA would. So I'm in support. Thank you.
Thank you. Anyone else? Hearing none, I'll close out public comments. Thank you. You can have a seat for, thank you for the presentation. So at this time, council, we can, I can't see nothing. I doubt this is going to be consent, so.
I mean, we have to have a public hearing anyways,
Yep.
right? So it
Yeah,
can't be
so
consent.
this can't, right. And then 905 is going to come later, correct? Okay. All right, so with that, we'll have this next week. Okay. We'll move on to the next item, which is Mr. Kaiser to discuss the initial proposal of a traffic calming policy. Thank you, applicants, for coming.
So what you have before you is the proposed traffic calming policy. And I'm just going to read the purpose because I think it's important that it really sets the tone for the rest of the policy that we'll be talking about here this evening. So the idea of a traffic calming process or traffic calming policy is provide a process and procedure to effectively reduce speeds, cut through traffic, improve safety for pedestrians, bicyclists, as well as motorists. And so that's really the purpose of a traffic calming program. As you know, we do not have anything of that nature at this point in time in our ordinance. So the impact on this, the process by which you carry this out, seems as if it's cumbersome. In actuality, it's not. It's a matter of getting used to in terms of how you implement something of this nature. So the first thing that is done under this is a petition that is submitted to the staff, to the city manager. It's that petition, that initial petition, and there's a petition process and format that I've included in the policy as well. That initial petition allows staff to look at the location. It allows us to look at the technical information that's required and also whether funding exists for the program. Because, there are not a lot of residential streets left in the city that this would pertain to, but there are a few remaining. And I think this provides you with the procedures and programs to uniformly look at all locations in the city. I know there was a comment here a while back about that we don't want to spend a lot of time on technical information, data, and I agree with you. It does not have to be done that way. I can do most of the evaluation myself with one exception, and that is you have to collect traffic data. You have to do volume counts. And that has to be done by somebody that does it for a living all the time. And that's a very, very low cost to do that. So I think just from a funding standpoint, which is not really what we're talking about today, but it's worth mentioning, in the SPLOST program, we do have really two areas where we have identified traffic calming. One is an actual traffic calming category or a project of $100,000 in there. There's also some monies in there for pedestrian improvements in North Indian Creek Corridor. We talked about the SS4A program. We can apply that to the SS4A, or we can allocate those for traffic calming projects as well. I think the council has a lot of flexibility with that. So there are certain minimum things that need to be looked at before you even consider whether a petition is valid or not. And I laid those out on page 3. It's Roman numeral 2, minimum requirements. I'm not going to read through all those. You can look at them yourself. But I would suggest that you do look through this policy. There's a lot of detail there on how you would go from a petition, initial petition, to a final petition, because there are streets that just do not qualify. Streets such as collector streets, arterial streets, minor collector streets, minor arterial streets. There's a number of those in the city that just would not qualify for traffic calming. So we have to look at that as number one. But also whether funding exists. We talked about whether funding is even there to do it, whether there actually is a problem with speeding. You live on a residential street, and we all do. The perception is that people are speeding all the time. So one of the very bare minimum requirements is what's called the 85th percentile speed. 85th percentile speed is real simple. It is the speed at which 85% of the cars travel on that road meet in terms of traffic speed. The 85% of the vehicles. You have to have at least what I put in here, I think I put in here 35 miles an hour. 35 miles per hour or higher 85th percentile speed. That's a high bar, but that is the bar that almost every government that I have ever worked with in the past all follows the same procedure, because that is what's defined by the Institute of Traffic Engineers, ITE. This is something I have dealt with my entire career. I developed the first traffic calming program and policy in Rockdale County in 1992, very first one. So I went back, this is just kind of curious, a little side note, I went back to Rockdale County's website, and guess what they had? They still had the policy in there for 1992. They haven't changed it. They still follow it. And so it's really the same kind of policy. I mean, you go across the board, and DeKalb has something similar to this. The process is a little bit different in terms of petitions, but it's all basically the same thing. But it gives council the ability to fairly represent their constituents in terms of whether a traffic calming policy and program and implementation is appropriate for that area. And when a citizen submits a petition, they're going to automatically think, right, that it's valid, and that you need to put in speed humps or chicanes, which we don't like, or other devices, right, other things. And so the other part of the policy is the cost. So this is where it gets a little bit different. Every government applies a different cost to the taxes, to the tax statements, to what is actually assessed to the property owners that live along that roadway or the traffic calming location area map. And so what I did was I looked at the cost to put up a traffic calming sign. Just take one sign that you have to put in on each approach to the traffic calming area, all right? One sign costs $300. Signs get knocked down all the time. So instead of arbitrarily, like a lot of governments do, assess a yearly fee or tax, in this case, of let's say $35 per parcel. Well, that doesn't go very far if you have 3 parcels or 5 parcels or 6 parcels along property. How does the speed hump program or the traffic calming program pay for 2 signs that are knocked down within 3 months of them being installed? It doesn't pay for itself. And so what I've done is I have looked at the cost per traffic calming device. Instead of just an arbitrarily $35 across the board, a cost of per traffic calming device, whether it's a chicane or a speed table or whatever it may be. And so that's how I've developed the estimate of cost. The other item is traffic striping. So one of the things I strongly recommend, and I'm going to just say it here now, what we have done on Rogers Street is inadequate in terms of striping. It needs to have more striping. Everybody does more striping. Every government does more striping for liability purposes. So one of the things I'm going to recommend at some point is we need to go out the next time we have striping in the community, go out and stripe those speed tables the way they should be striped per ITE. Just protect the council and the mayor. So striping costs. You use thermoplastic striping. To do thermoplastic striping on one speed table, just one speed table, that cost is $150. And you have to restripe, even with thermoplastic paint, every 5 or 6 years, so it's not faded. So I want to be sure that whatever is charged to the homeowner, it may not fully pay for all of the maintenance work in a traffic calming area, but it should come close. It should be neutral or come close to being neutral in terms of cost to the government. So that's an important component of this, a very important component. So that's what we have, and I'm sure there'll be a lot of questions that come through, and I think it's appropriate because this, there are at least one petition or 2 petitions that have been submitted, I think, to the city manager, the previous city manager, and I think to you now, for consideration for a speed control traffic calming measures along a roadway.
Thank you, Mr. Kaiser. And before we start, City Manager, you had a chance to look at this, and can you let us know your impression in terms of following through and everything with it?
Yes, ma'am. This policy isn't different from the similar policies we've administered in local governments previously. I think I want to ask Mr. Kaiser to clarify his assessment of costs in the policy in section 4. I think 414. It says each property in the affected area will be assessed on their property tax bill a $20 fee for each traffic calming device. So that's the amount that you were just speaking of. So that $20 would be fixed if council approves this policy.
Per
parcel.
device.
Per device.
Per device, per parcel.
Per parcel.
Yes.
Okay. Yes, ma'am. I think that's adequate.
All right, and at this time, council, do you have any questions? Okay, hearing,
I did have a brief one. So I may have missed it with all the information, but how are you determining affected properties, just anyone along that street, or do you have a particular radius?
Zone of influence.
Zone of influence. How's that determined?
So what I mean by that is, let's say we have one on Pecan Street, and we do, right? And so if you put speed tables or any other traffic calming devices on Pecan Street, where does that take you? Where does the traffic go if they avoid that street? Go over to Jolly? Are they going to go over wherever they're going to go to Mel to avoid that speed program? And so that zone of influence is determined by staff looking at the big picture, saying, okay, we put speed tables along this road. How does it affect the neighborhood next to them? So then we say there is an influence. The adjoining two streets are going to have an impact. So guess what the petitioner does that submits the petition for Pecan Street? They have to go to their neighbors on those streets based upon staff recommendations and go out and get signatures for those other two streets. That's how it works.
question?
Thank you.
Okay. All right, hearing no other questions, do we have any questions from the public? All right, we'll close that one out in terms of public comments. So, council, what is your idea in terms of this proposal?
Consent agenda.
Oh, consent agenda. Okay.
Yeah, I think consent, I think we need a procedure because otherwise, I've done this before and just kind of episodic depending on who in the street can get the council's ear and things like that. So I think this should be consent.
Okay, consent.
It's very thorough. I mean, it's.
Okay. All right, so consent.
Madam Mayor?
Yes.
So when I discussed this with Mr. Kaiser, we thought that there would be a lot more deliberation by the council.
Mm-hmm.
So what we have is a policy document.
Mm-hmm.
It's not an ordinance.
Right.
And the reason I think the element of this by which properties are assessed a fee on their tax bill, I think requires an ordinance. And I also want to take a little bit of a look at that. So my request / suggestion would be to put this to the next month for final adoption.
Okay.
So that I can come back with number one, an ordinance, and number two, an ordinance that complies with Georgia law in terms of assessing a fee.
Okay, so you would like us to defer this to the next month's work session?
Yes, with an instruction for the city attorney to develop an ordinance to implement the policy.
Okay. Hearing the city attorney's recommendation, is that something in terms of consent for that piece of it? Because this is a policy.
Yeah, no, I agree. For taxing, it needs to be.
That's fine.
It's fine? Okay. All right. So, Madam Clerk, do you have that? Okay. All right. Thank you. And thank you for that point, City Attorney. And we'll move on to discuss a transfer of an alcohol license application to Dilliet LLC DBA 76 Food Mart located at 4556 East Ponce de Leon Avenue, Suite A, Clarkston, Georgia 30021. And Madam Clerk.
Yes, the owner of Dilliard LLC DBA 76 Food Mart has made application for an alcohol license for beer, wine, and malt beverages at the convenience store 76 Food Mart, which is formerly Mighty Money Inc. DBA 76 Food Mart. The Alcohol Review Committee has received and reviewed the new alcohol license application, verified that the zoning compliance has been confirmed, the business license has been issued, and all required on-site inspections and measurements have been completed. Background checks have been conducted. However, staff is still awaiting the results of the fingerprint background check, which are expected to be received prior to the August 7th City Council meeting. Under Chapter 3-54D of the city's code concerning alcohol, I'll go ahead and read the code for you all. A grandfathered license may be transferred to a new qualified licensee, or a grandfathered license may be issued to a new qualified licensee in connection with a change of ownership. A new qualified licensee that obtains a grandfathered license pursuant to this subsection shall be subject to all requirements and limitations for grandfathered licenses. In accordance with Chapter 3-54D, this alcohol application is considered a transferred grandfathered license, and the applicant is present if council has any questions.
Okay, thank you, and thank you for that. And you approve this one? Recommendation.
So right now, the fingerprint and backgrounding check is still pending. We should expect the results by August
Council
7th.
meeting. Okay.
Correct.
Okay, thank you. And City Attorney, did you have anything else just to make sure? Because I know we had a lot of rigmarole between what we had previously to what we have now. And I guess I want to make sure in terms of setting the stage for the council to have the deliberation, if you need to add anything before we start with the conversation.
Okay, well, just to set that stage, we previously amended the code section dealing with these convenience store alcohol licenses to allow them, they're now all grandfathered because you can't get a new one. And what the action that the council took, I guess last year, was to amend the code so that those licenses could be transferred to a totally different licensee, but at the same location. And that is my understanding of what's being requested here. So the council's role would be to check on the factors that make a person qualified to hold a license.
Thank you. And if the applicant wanted to come up and speak, and then state your name.
Hello, my name is Masarat Dajani Ballata.
And I need you to speak, come a little closer.
Okay, my name is Masarat Dajani Ballata. I'm the owner of the 4556. More.
Yeah, the 4556 is to Ponce de Leon Avenue, which is Delete LLC, 76 Format. She's my wife. She's the licensee. She will be for new LLC.
Okay. All right. Thank you. You're fine. I just want to make sure if you wanted to say something, you could say it. So, okay, great. You can have a seat. Thank you. So, council, at this time, do you have any comments?
As long as it's compliant.
Okay. With that, no comments. Public comments at this time? No public comments. Okay. We'll close that out. For this one, we still have to wait until Thursday because we're still waiting on information. So we'll just wait until the Thursday next week. Okay. Thank you for coming. And then we'll move on to H, which is to discuss Chapter 3 of the Code of Ordinances pertaining to alcoholic beverages, and that is Mr. Edwards.
All right. Thank you, Mayor and Council. So on this text amendment here, we are requesting the following changes. So the first change would be section 3-9. We're removing the reference to the zoning district C1, C2, and C3. I'm not even sure the last time we had those zoning districts, so we're completely striking them from the alcohol code. The next section we're changing is 3-55, and we're removing the proximity requirement for on-site consumption for churches. So there would not be a distance requirement for on-site consumption based on a church being next door. The next code section is 3-55, and that's going to amend to say no license shall be issued where an entrance to a place of business for the retail sale of beer, malt beverages, or wine for consumption on premises is located within 100 yards of a school, school ground, or public park, or the entrance of a library. That's the section removing the churches. The next one is D, which is no license shall be issued where an entrance to a place of business for the retail sale of beer, malt beverages, or wine for the consumption on premises located within 50 yards of the entrance of an adult entertainment district. And that is a reduction on the distance, which is currently 300 feet or 100 yards there. We're reducing it to 50 yards. The next section is section 3-7. The code is hereby amended to say within 50 yards of a single-family home dwelling located in a zoning district that permits single-family dwellings. On that one, it also referenced zoning districts that no longer existed in the city, so we're removing them. And the way this one reads is pretty much if you've got an NR1 home, that would be considered a single family. But if you have a single family home in a commercially zoned lot, that would not count for the distance requirements here. And then the next one is subsection 3-96 is amended to be within 200 feet of a school grounds or public park or the entrance of a library. That's removing the church requirement for on-site consumption for distilled spirits. The next one is on-site consumption for the distilled spirits as well, which is section 3-96. We're reducing it from within 150 feet of the entrance of any adult entertainment establishment. And with this, I believe staff is recommending approval on these on the basis that we have received comments businesses have closed in our downtown because of their proximity to a church and not being able to sell alcohol. And we've got current businesses who are saying that they are under distress because they can't sell alcohol and their sales aren't where they need to be. So these are being proposed based on comments we've heard from business owners here in the city. And with that, the city manager or the mayor.
All right, I'll let the city manager talk on this one.
Yeah, I have a quick question. Are these in line with state regulations as well?
For on-site consumption, the state does leave the distancing requirements to counties and municipalities for those distance requirements. So the state does not have a regulation for either of them.
Thank you.
Okay. Any other comments, Councilman Carroll?
So for the 3-96, what is the current limitation for adult entertainment? I saw it's moved to 150 feet.
So currently for the adult entertainment, it's 500 feet.
Okay, so this is basically just making it so they could be in the same shopping center.
So for example, one establishment that we do have here in Clarkston, it pretty much eliminates the entire shopping center from being able to sell beer or wine if a restaurant were to go in.
Okay, that answers my question.
Okay. Any other comments? Yes,
Just a
Councilwoman.
question. How does that differ from the section 4 that changes to subsection D of 3-55?
So 3-55 is going to be in relation to the sale of beer, malt beverages, and wine, and 396 is based on distilled spirits.
Thank you.
Yes, Vice Mayor.
On section 3C, what was the yardage for schools, playgrounds, parks, libraries before the amendment?
We have not changed those distance requirements. We've just removed the word church from that. So churches aren't considered in those distance requirements.
So we do not have distance requirements anymore for churches?
This text amendment would eliminate the distance requirement for churches just for on-site consumption. So that's a restaurant selling inside their business. Liquor stores, reproductions of different alcohols would not fall under this ordinance. That's under a different section of the alcohol code.
But that remains?
Yes, ma'am. So this is just for drinking inside an establishment that has a pouring license.
Okay. But not for them taking off premises.
Not off premises. There are patio regulations where they could go on a patio, but it does have to be fenced in, so they could not legally leave the property with any alcoholic beverages.
Okay. Any other comments? Okay. I'll open it up to the public. I know nobody wants to say anything. Okay. Do you want consent? Consent? You abstain, okay. All right. Man can't nope. Nope. Okay. All right. Thank you. So we'll just have this on the agenda. Okay. So just so everyone understands, we have consent agenda. If we need to have further deliberation or for whatever reason, council person has the right to say no or abstain, and if that's the case, then we have to just put it on the agenda for a vote, and that's what we plan to do for this item. So the next one is, what did I do with this? To discuss the Affordable Housing Assistance Program. Councilwoman Hood.
Yes, thank you. Let me begin. Richard, I had a handout and I neglected to give you a copy of it. There is probably one on the back table if you want to get that. The intention tonight is to just discuss a couple of points. The research that I have done has led me to some questions that I think a good approach would be to try to understand what council is inclined to do and or not to do with the monies that we have. And from that standpoint, then it will assist in identifying all of the uses and how much we can apply to the various uses and that sort of thing. So this first paragraph just quotes the trust document, and it identifies how the money can be used. Certain qualified low to moderate income individuals with funds to assist in purchasing, repairing, and or leasing eligible residential dwellings in the city of Clarkston. And so from that standpoint, there are some requirements that will apply to whatever program we use this funding for. And one is that the property in question has to be within the city limits of Clarkston, that it apply to low to moderate income individuals or families, and that there needs to be a residency requirement. Typically what I see is 3 years, that if somebody is applying for one of these programs, that they would have been a resident in the city for 3 years, a minimum of 3 years. Now, as I say, that number is what I have typically seen, and if that is something y'all want to discuss or change. So taking the first item, first-time homeowner assistance, I've been running some numbers with the assistance of another organization, and 100% of AMI is the midway point. Some of the programs out there to assist with the down payment start at 120% of AMI. That is not considered moderate income, so that would not comply with the terms of our grant, of our trust. So I ran some numbers looking at somewhere between 90% to 100% of AMI for a family of 4. and came up with a number of, based on, the 30% that they cannot go over, that you're not supposed to go over as a cost for your housing. And assuming a down payment of 10%, a house about $380,000 would be affordable in the 90 to 100% of AMI. I know of one program that goes up to 100. So if that is the sort of thing that you would be, I just want to throw that out there and see if that is in line with what your thoughts would be if we did a down payment assistance program. That would be basically our target of eligible people. Below that, they would likely not be able to afford a house at $380,000. And the most recent medium sales price in Clarkston is about $340,000. So these are just round figures. And if that is something that you think would work, then that's something that we can put into our plan. And so in addition to that, we need, and this is something we need to establish, and the plan needs to be that detailed about, the extent of the funding. But going along with that, we need to discuss what percentage of a down payment we would want to contribute. A down payment, 10% down payment on a $380,000 house is $38,000. So are we looking at funding all of that? Are we looking at funding a percentage of that? Are we looking at making this a grant or having any repayment of it over time? We need to think about the length of time that an applicant would, or somebody who receives a grant or a very low cost loan or a zero cost loan, how long would they need to stay in that house before they sell it, and for us to feel that we have put our money in the right place, if you see what I'm saying. This is to get people into a house. And so if we're talking about, the numbers that I used were a 30-year mortgage at 6.75%, which is more or less what's going on now. So these are all things that we need to think about from the standpoint of getting all of these details together. Let's see. There was also a suggestion that of how we might reduce the monthly payment, because houses have gotten more expensive now. And I think one of the ways is to put in a 10% down payment instead of a 5% down payment. But again, that's more of a draw on our resources. And all of the programs I've looked at include homeowner education. And then there are some of them, if we go through a financial institution, which is what most entities do, they will need to be able to qualify for the loan, because that's a requirement of getting the loan. And it has to be their primary residence. And then another aspect of it is setting the maximum assets that an individual applicant can have. And that gets back to the use of our funds. If somebody has a low to moderate income, but they've got a huge amount of assets, which are different than income, then we need to take that into consideration. So there are a number of things in here that we need to talk about, maybe not as specific as you care to be, but if you want to speak about your intent or how you would like to see this done, I think that would help in going forward with this. Do you want to pause for questions, or shall I keep going about?
Let's go through all of them, because we have to know what percentage go to what.
I'm sorry?
I think it makes sense to go through all of them now, because we have to know what percentage go to what. We may like some of these, but then we have to say, okay,
Right.
we want
And-
X percent to that, or.
Right, and that's my last question is, where do we want to focus the funding?
So I want to step back, and I want the city attorney to clearly explain the money that we're getting so that we can separate the two funds, because we have the existing 200,000 and then we're getting the 90,000. And so I would like for you, before we proceed with any further discussion, to provide the clarity for council to understand, as Councilwoman Hood is working on this, but for us to be able to kind of give her the guidance in terms of moving forward with the topics that she has or adding to it. I think it would help the body to understand.
Sure. Happy to do that, Madam Mayor. So the Affordable Housing Trust was created in 2019. I believe that, and it was the seed money that created the trust was contributed by the developer that built the townhomes on Church Street across 285. I think that amount was $250,000. Subsequently, the mayor has obtained a commitment from the DeKalb Housing Authority, and that's been approved through an IGA by both bodies, where that entity is going to contribute $90,000 per year for the next 20 years.
Or is it 15?
15 years. Yes, thank you. So that's, I'm not even going to try to do the math on that, but it would be 1.3 million. But it's only going to be coming in, on an annual basis. I don't know whether we should not have spent any trust funds because we've never adopted the plan. So right now we should have a balance of 250 that will go to 340 this fall. And both of those sources of funds go to the same place and then are used in the same way, which is pursuant to this plan that y'all are talking about. And just really quickly, the trust document governs this. That's not something that the city council can change because it was the terms and conditions upon which that developer gave this money to get it started. But it contemplates that the city council will make this plan, which are essentially the rules for spending the money, within some very basic guidelines that Councilmember Hood read at the beginning of her remarks.
Okay. So if you would like for her to talk about or just kind of give an idea of the proposed points, and then that way she can continue. Well, she didn't talk about the
She did the first one.
She just did the first one.
Right.
And so I want to make sure from a time constraint. Okay?
I'll get through that. That is the most complicated one.
Okay.
The next is rehab and restoration. And again, we would need to talk about the maximum grant or low-cost loan, what percentage of cost or 100% of cost. What we're contemplating here is major things, for instance, rehabbing a bathroom if somebody now is, along with ADA requirements, or if there's a major problem with the house, HVAC, that sort of thing, that would mean the house is no longer livable. So again, we need to look at how we want to approach that. Another thing that's come up is the possibility of doing that rehab for someone who is in a rental home. Now that gets much more complicated, and if we want to go that way, it's going to be complicated because there's no benefit to the low-income person. It would be the person who owns it. So I'm not sure how we could make that work, but I just raised my hand on that. Another aspect is foreclosure assistance. If somebody has an imminent foreclosure and it's related to a one-time situation, and if we stepped in with a short-term loan, something like that, but it would have to be exceptional case, not something that just puts off the inevitable. Another idea that has come up is the possibility of helping assist with the construction cost of an accessory dwelling unit. Now, again, the problem with that is somebody building an accessory dwelling unit is not likely to be low to moderate income, but if there were some agreement that they would hold the rental of that at a certain level for a certain period of time, that might work. Again, anything that's done that's not directly for the owner, I mean for the person who is low to moderate income, it gets more complicated. So with that said, I just have other on here if anybody wants to add something else that we should consider. And two other points. We are almost certainly going to have to contract out for this. This is, if we want to do, even if we just did down payment assistance, we would probably have to contract this out. But the more expansive the program, the greater the administrative costs. I've talked to the city manager about that, and she totally agrees. So then the final question, where should be the focus of this funding? The initial 200 and then going forward with the 90,000 a year.
And that's all?
You want to
Okay. All right. I see the city manager and then I'll recognize. Okay.
Oh, my question is going to be, as we work through, and I don't want to dismiss your question, but I think it plays into, we need to consider this. As we work through this housing landscape scenario with ARC and the information that they are gathering, I think the findings from that should help us to determine the need for, those different points within our housing, within the trust, right? And so I think that as we get that information is how we define this plan. So we are considering these things ahead of the information from the housing study. That's what I'm saying.
Okay. Okay.
Yeah.
All right.
Can I just throw
Yes.
in one thing real quick? There's the potential for additional affordable housing funds to come in through the trust. So we're not necessarily only dealing with the dollars we know about now.
Right. Okay. Yes.
And one more thing, the finance director has verified that there's $200,000 in the fund, not 250.
Right.
Yeah, that was the original.
Yeah,
Okay.
that was, yeah.
Yeah, thank you.
Yeah. Okay. So with that, yeah, it was 200, I think, because Dean.
It was 200 back when we approved the town.
Mhm.
That was it.
Right.
And it's been refilled since we spent environmental assistance and got refilled with federal money.
Right. Okay. All right. So just want to make sure you're clear on that one. All right. So hearing what our city manager, and I think from a guidance perspective, that's kind of what you're looking. Do you want us to kind of maybe, city manager, put this on pause until we get back that information? Because I want to make sure in terms of the funding that we are in compliance with what we have in terms of the IGA. And so, right.
So what is the anticipated timeframe to get something back?
Do you know the timeline for the housing? I know we have two
Just a
more housing
guesstimation.
summits. I would say, I think it's September when they give the report.
Yeah.
It's September.
That's good enough.
Okay. So, Councilman Carroll.
I'll be brief because it's late. But so basically, the distinction I'm thinking about is the first one, homeowner assistance. The second one is assistance and financing. The homeowner assistance is a demand subsidy. Basically, you're subsidizing someone at the purchase point. And then the assistance and financing would be more of a supply subsidy in which you're subsidizing the construction of something that might not otherwise exist. I mean, I think they both have their place. The problem with demand subsidies is it kind of raises the bidding, right? It basically makes the bidding of the house higher than it otherwise would have been. And the person may still end up getting outbid by like a cash only or some deep pocketed person. It causes other problems. And then supply side, I mean, it has its own problems with administration, things like that. But I would think about financing not just ADUs, but other developments, and basically in the condition that they either sell it for a lower price and keep it sold for that lower price, or they rent it for a lower price and say, we'll provide you financing at either low or no interest rate. In exchange, you have to keep the rents at X level for X number of years. And that's kind of like the federal low-income housing tax credit program, which has been successful, in which they provide much lower interest rate. In exchange, the landlord has to rent it for a much lower price. And you could do the same thing for home ownership. You could say, we'll provide you financing for X amount, lower interest rate, but you have to sell it for X price. And then if you do that, then the funds get repaid and you can just keep on cycling it out. And so that basically makes it a perpetuating. So to me, that's more attractive to do a financing, not just for ADUs, but for any sort of affordable housing where the developer promises to keep the rent at a certain level or the price for sale at a certain level, because then you can just keep on supplying more affordable homes.
All right. Thank you for that. Anyone else? Councilwoman Bell?
Yeah. Thank you, Councilmember Hood, for all your due diligence with this process. Did this go to the Housing Committee?
I'm sorry?
Did this go to the Housing Committee?
No, not yet. Well, no.
Okay. So I think that's one of the steps that I would like to see, to just get general input from the resident, because I think this is more complicated than what we think, right? We discussed this before. We have a limited amount of funds, despite if it comes on a consistent basis or not, right? So we got to identify who's our target universe with appropriate criteria. Like, yes, there needs to be criteria associated with what affordability looks like, dependents they may have, if this is their first time, all those things need to be listed. In addition to that, we need to figure out what our theory of change is. What are we trying to accomplish with this program that aligns with our strategic plan for the city that I know that we requested at the beginning of this year for the city manager and admin to start working on. And all of that needs to tell a story about, instead of being ad hoc. So I do think that there's an opportunity to collect more data from general public in regards to this. There needs to be specific criteria on who we're targeting in this full universe, because we have limited funds. We don't know if it's going to come or not. And then I think also we need to figure out how do we define success, and what is it that we're hoping to accomplish as a city that aligns with our future vision as we continue to grow. So thank you for your work thus far. I do think it needs some deliberation and more input from our residents.
And to your point about the specifics, who's eligible, et cetera, or the city attorney, that must be in there. And I think a policy statement or a goal statement that goes along with it, focusing on just what you said, what are we trying to accomplish with this, would be helpful, and to keep us on point about. But all of these details, they're just dozens of details in almost every of these potential programs.
All right, thank you, and Councilman Perkins.
Thank you, Madam Mayor. Yeah, and I think, just want to reiterate, I think that's what's important, even before we get into the details of identifying the problem we're trying to solve, which I've heard echoed by a number of folks here. Even looking at these numbers, and I won't go into a ton of detail on our experience. My wife and I actually had to go through a down payment assistance program, so we're very familiar with how these work. We're also very familiar with how the market reacts to a buyer going in with that little down payment assistance asterisk buyer loan. So we are, I won't get into our economic details, but we qualified for a hardest hit fund grant, which provided $15,000 in down payment assistance. About half of that went to closing costs. There's insurance you need to consider as well. There's a lot of other different factors to that. Looking at current housing prices, I'll be honest, we couldn't afford to go through a program and do this, especially not with 4 kids. So I think having a clarity, and I believe the Vice Mayor actually mentioned this as well, when we're talking about affordability, what do we mean? When we talk about access, what do we mean? I think at our city retreat, I think it's absolutely critical that we define not just the problem itself, but also the scale of what we're even able to attain or to get. Because otherwise we're going to make false promises to people. That's not something we want to be doing in this housing market with all the other economic challenges that people are facing. I think we're in agreement on that too. So,
Right, yeah. Okay. All right. So you have direction and clarity.
I want to ask Richard if he has anything to add to the discussion.
Okay, thank you. So with that, I'll allow the public, if the public wants to make any comments, yes. Come to the mic and state your name.
Hi, my name is Kevin Doe. I am a real estate broker. I help purchase, sales, house quite a bit in city of Clarkston as well. I have worked with another program that I can share. Instead of having a certain number of years that someone live in a home. So we're ultimately trying to do is improve the home ownerships for Clarkston, right? For people who lives here. And even new residents, not just residents here, but want to bring in new vibrant life to the city of Clarkston. And instead of having a forgivable loan, if they live in a home for 5 years or 7 years or 10 years that they have done in the past, I've seen a program that give a very significant amount, but there's no limits on the number of years that they live there. As long as they have to live there as their primary home, so they cannot own it and live there for 5 years and turn around and rent the home. As soon as they do that, there's a repayment period. There's gonna be percentage of interest charge. So what you want to do is to grow the funds so that the city can grow along with the citizens to grow, and not for someone to take advantage of a certain amount of funds and take off. Because as we can see, residents that lives in the city of Clarkston do stay significantly longer than other cities as far as purchasing, moving in, growing kids and families and residents. I myself, our families of refugees, we've been here since 1993. So I've seen a lot of changes, but as far as home ownership, if anyone's moved out, when they sell the home, there's a certain amount of money. Let's say if you put 10%, $30,000, $35,000, plus the interest for the last 5 years, 10 years, 15 years, whatever it would be. So that would be going back into the funds. And at that time, there's going to be more residents. So that money never leaves the city of Clarkston for the purpose of growing the cities with home ownership. And I think that's going to help with people to advertise it for you with, like, say, constructions or renovations or ADUs and so forth. So you're going to spend so much more time, energy, efforts, money to advertise this program to the general public and to thoroughly for them to understand it, to apply it, an application. It's going to be a much more difficult process to maintain and versus a first time or someone who's buying it to live, not necessarily being a first time, but they just don't own a home in the last 3 years or 5 years. That's a definition of housing authorities, right? As first time home buyers, so they can, is it, my time's done?
Yeah.
Okay, so
Okay.
that's just my 2 cents.
All right,
you.
thank you very much, very much. And so make sure you reach out to Councilwoman Hood. So we appreciate that. Anyone else? Anyone else? Okay, with that, we'll close that out. And we have marching orders, and I'll take a motion to adjourn.
I move to adjourn.
Second.
Okay, it's been properly moved and second to adjourn. All in favor say aye.
Aye.
Motion passed. Meeting's adjourned.